He's saying that in the meantime, husband
has been acquitted.
May I pardon your lordship?
Judgment is your lordship.
On the ground
Judgment
of,
is your lordship, reserve the judgment.
so that matter has been, your lordship has reserved the judgment.
Reserve the judgment.
Yes.
May I?
Do you have that equitable order?
No, I have given the memo. I have applied for certified copy. In case of any query, my lords, your lordship can also, your lordship can also call for a report from the learned trial court.
Now you have said that.
May I pardon your lordship? May I pardon your lordship?
This is a matter 482 that the ED case that similar order your lordship the 205 application has been rejected. Same your lordship has directed that which will be granted and he also appear in
Offense?
ED case now. Enforcement.
ED counsel is not there. Mr. Agarwal, I will let ED.
Let it come tomorrow.
Tomorrow, you know,
Small matter you are covered by your lordship.
small matter, but small.
After the Supreme Court judgment, 4 days back,
That news.
everything is covered to my lord, only to dictate the order. That much.
The Taslim Lal case.
They have put
I
that as
know.
para
Para
23
23
is very
D.
clear.
D.
Even allowing 205, everything.
Para 23D. Recently, I passed 2 orders.
Immediately I had the plus and I had to send it.
Take it, let us see. Because tomorrow it will be very tough.
Actually, small matter covered by your lordship.
Asile so? Number is not also there.
Number I guess the diary number
Number कौन था ना? Number कर दिया mention.
May I mention lordships?
May I pardon? Thursday list.
Keep all the memos.
No, my lord, Thursday list is a Belgium matter. Your lordship set aside the inevitable order. But after ST case number, one number, extra number is added in my order sheet, downloaded copy. I will not obtain the certified copy, your lordship.
Not obtained.
No, not obtain the certified copy. Extra number 38/246 of 2016. More ST case number is 45 of 2022. तापर ଗୋଟେ extra number add ହେଇଛି ଦି ଜାଗାରେ.
Okay. Good. Now just see future. Because just now I corrected one.
My lord.
वो ईटा ही थे पर है देखिए.
वो certified copy नहीं आगे.
I just I have corrected all that.
My lord.
I corrected. Press download you. Just now I have corrected.
My lords, may I mention lordships?
Now you can take certificate copy. Ignore it. You take the certificate copy. Give all the memos.
My lords, may I mention on the virtual mode lordships?
My lord, 134, my lord, not press withdrawn, my lord. Item.
We'll go page wise.
My lords, may I mention on the virtual mode lordships?
Yes.
My lords, urgent matter, my lords, that person is a 65-year-old person, my lords. We have filed for quashing in 498A. He is the maternal uncle of the complainant. And it is a 2022 FIR, lordships. May kindly take it up tomorrow, lordships. I need some protection, lordships.
Protection is from the court.
My lords, absolutely. My lords illustrate there is a case for quashing, but my lords, the urgency is that the 65-year-old person, lordships. 2017 marriage, 22 is a FIR, and is the maternal uncle, no relation at all with the.
When have you filed the petition?
My lords, it's filed on the 16th, lordships. It's registered, my lords. I'll give the CRMC number, my lords. My associate Devasis is there, lordships.
Check number just.
Give the number, we'll see.
My lords, it's given, lordships. Devasis, my lord, associate has given. Kindly put it for tomorrow, lordships.
Give, we'll see.
Grateful, lordships. Grateful.
I beg your pardon to mention, my lords.
Yes.
My lords, item number 99, CRLMC 5101/2023, my lords. May kindly be taken up after vacation, my lords.
After vacation, 99.
Item number 99, CRLMC number 5101.
Okay.
Interim order to continue, my lords.
Who is appearing for the other side?
Awaiting service.
State, my lords.
Waiting service.
Awaiting service.
State, my lords.
Pardon to mention lordship, one CRL.
Let us go page wise so that it will be easier.
Page one, not listed.
Page 1, item 1 to 6. Page 2, item 7 to 18.
Item 9, my lord. After vacation.
Item
14, lordship, kindly be taken over after vacation, lordship. Your lordship, item 10 after vacation.
14.
My lord, item 11, my lord, after vacation, kindly.
Why are you getting it listed?
Item 10, your lordship.
10?
Item 10, after vacation, my prefer after vacation.
Page 3, item 19 to note 29.
My lord, item number
Dependent lordship.
26, my lord. After vacation, my lord.
Just be careful if there is a interim order,
26.
just take it up.
27 your lordship after vacation. My friend is there.
The opposite party.
My lord.
Last. Interim order is there.
No, my lord. Fresh matter.
Fresh.
Oblige, your lordship.
Page 4, item 30 to 44.
Item 42, Miller. There is a connecting matter relating to contempt violation of your lordship's order. That connecting paper has not come. Because giving the number.
Give the number. Okay. Connecting matter has closed here. Next. Page 5, item 45 to 57. Page 6, item 58 to 66. Page 7, item 67 to 78. Page 8, item 79 to 88.
My lord, item 83 can you take up after vacation?
83.
82, my lord. After vacation.
80.
88.
88.
82, my lord. I prefer after vacation. Interim order is there, man.
Who is the other side?
It is the other set notice was issued. Awaiting the issue.
Publish.
83. Who is appealing for it? You
Like 83 item.
for settlement matter.
Notice was issued.
We don't want to do unnecessary. Page 9, item 89 to 96.
My lord, 90 I prefer after vacation. No interim order.
Page 10, item 97 to 105.
My lords, item 99, I mentioned it earlier, interim order to continue, my lords.
Interim order to continue. Wherever I.
Much obliged, my lords.
Statement interim order. Page 11, item 106 to 112.
That's item number 106 minutes. Lordship would call it after vacation minutes. A
Interim-
private opposite party interim orders to continue. It is not back.
It is complete.
Minutes.
Service complete. It is not back one.
It is not back.
Okay, interim order to continue. Just take it up. Don't vacate the interim order wherever.
My lord, 111. My lord, 111. Parties are present. My lord, matter is settled.
12 o'clock.
Take.
12 o'clock. Yes. Page 12, item 113 to 118.
Item 115, last occasion your lordship was directed for appearance of the accused persons arising out of a matrimonial dispute. A case has already been settled, my lord. And notice has been served twice, once in register post, once in special messenger.
What do you want?
I don't take it before launch because the 72 years,
Up 12 o'clock.
12 o'clock, my lord.
118 after vacation. 118 after vacation.
After vacation. Page 13, item 119 to 125.
Let's say item 122 kindly be taken over after vacation. Let's say interim order to be continue.
119 and 122, both the items were taken up.
119 and 19 and 20.
Sorry, what is service?
Sorry, vice. Interim order continue.
125. Somebody should come. 125, anybody there? No. Item page 14, item 126 to 137.
Let's say item 126, let's say kindly be taken over after vacation. Interim order continue. Maybe 134 not first matter. Interim order continue.
126. Page 15, item 138 to 140.
Item 139. I am from the opposite party. The 138 and I matter against conviction. I pray after vacation.
After entry order is there.
I am from the opposite party.
Division matter.
It is against conviction.
Again.
Resource for
Item?
My lord.
Lordship,
One after another. Yes.
Lordship, one CRLMC number 1139/2012. As per the direction of the export, we went to the mediation center. Mediation already succeeded on 15/12/2023. Kindly listed for tomorrow, Lordship.
Mediation successful.
Yes, Lordship.
ले लो.
My lord, in this case, this is the matrimonial case already compromised petition and affidavit already been joint affidavit already filed. My lord has passed order to today will be listed, but it has not been listed. My lord, kindly listed it.
Where are the parties?
Party अच्छी कल डकदेवी आज तो लिस्ट है लाने में लास्ट दिन
Matrimonial.
मैट्रिमोनियल पूरा कॉम्प्रोमाइज है
Kali कर दिए. Yes. Belgium to give. Belgium.
Belgium matter.
The matter has been settled.
Yes.
The offense under section 363. Both are relative, my lord. Close relative.
We'll see.
Tomorrow, my lord.
We'll see just how many matters. 500 matters can't be taken up.
My lord, my lord.
My lord,
Your lordship.
The crowd.
matrimonial matter already compromised.
Keep the.
Not-
My lord, I'm mentioning a matter which was listed on 8th of May. I missed the matter because my name was repeated on two items, item 40 and item 60. And petitioner here is a senior citizen. And they are being compelled to sign bond before executive magistrate. Kindly take up this matter. My lord, may
What happened to that matter?
I missed this matter. It has been adjourned to 28th of August. So kindly allow me to at least withdraw. I can take charge before vacation because petitioner is senior citizen. And in fact, the complainant is the brother.
See, if it's so serious, you should be, careful.
I was there, my lord. I was there. In fact, and in fact, I have moved an IO also with respect to that. That is 1274 of 2024.
You want to withdraw it?
I want a preponderant of.
Preponderant, then you have to move application.
I have already moved that one. I have already moved that one.
No, what is the offense?
50634 and 294. The complainant is the brother of the petition number 1. Civil dispute.
You can try in the vacation.
Yeah. So I have to withdraw this one, my lord.
Application you withdraw.
So tomorrow I will. Today I will.
Today you move.
That
Yes. Item 1.
Item 1, if I may please, Your Lordship.
Yes.
On this case, on the last occasion, I've asked my lord to bring all the matters together. In both of the matters in this case, my lord, the petitioners are the State Bank employees, State Bank of India. So just to gist of the case, my lord, the petitioners bank, as per the advertisement, have asked for these credit card employees. That is for as per the scheme of the State Bank of India, my lord. After that, the complainant, he took that credit card for which he had to pay 4,000 rupees. After that, there was this, he was asked for an OTP from an unauthorized number. And the OTP was provided by that person. And after that OTP, the amount 35,000 was deducted. Hence the case. He submitted an FIR, written complaint, which is not registered. The legal notice, he has accepted the fact that there was the third party involvement, which is a cyber fraud.
So what do you want?
Basically, after the complaint 160 case, my lord, the FIR was registered, my lord. So to quash this FIR, my lord, because that does not have a stand. And the lower court has taken cognizance just because he's a lawyer in the court back in both.
These are big scandals.
They were not
No, my lord, I'm the State Bank employee, my lord. State Bank of India employee. I am not.
You are maybe involved. I know. At the cognizance stage, why should I interfere?
My lord?
I think first case is 1/6 case, my lord.
And other two cases? FIR.
Another case is FIR.
No, say 160.
हम देन हरी 1/6
Some 160.
FIR कॉल तो बस
No. FIR written on.
party, my lord, but no copy given to state.
But it is only cognizance. Let us see what are the allegations against you. Complaint, just see. Come to the complaint. What is your name? Your name is Pradeep Nahak and Sangram Shah.
My lord.
Come to the complaint. Come to. Come to the complaint, whether the case made out or not. Come. Read it out.
Para 6 of the
Yes, brief facts.
brief facts.
Come to the brief facts.
The complainant is a senior advocate in both district, and also he is a law-abiding person. The complainant has opened a SB account, number so and so, at
Number 1, 3, and 4.
my lord.
Insistently and persistently over and again, canvassed to the complainant apply for credit card of HBI. But the complainant have failed to understand there are hidden intention and their activities as per the achieving the credit card. The complainant succumbed to their pressure and the complainant applied for the credit card on good faith, depending upon the version of the accused person. All the accused persons have shared a financial transaction and other personal data of the complainant between so and so during the activation of the credit card by so and so auto debit cards. So complainant regularly used deposited understanding views also. So the complainant have received a message from SBI deposits from the complainant from Yes, page 3.
Page 3 of the
approach of the complainant to the accused number 1 and 4. Forget the express also, it page also. Please contact the customer care on the complainant inquiry and who is the person dealing with this matter in your branch is BM told to the complainant that the Sangram Sahu is dealing with this matter and he has sent the message to Mr. Sahu and who help the complainant in this regard. And after all these things, allegations are there.
No, my lord. That's the draft of the complainant, my lord. That's not the case. That's a petition drafted by the complainant. Then
obviously, cognizance has to be seen on the basis of the complaint.
No, my lord. My humble submission before lordship is
whatever, but see, these are the cognizance is taken on the basis of the ICC case with the complaint. There are specific allegations against you. Very, very specific allegations.
there are a ton of cybercrime frauds, my lord. My lord.
And cognizance is now taken.
My lord,
and if you are aggrieved, you can go and argue that at the time of framing of charges, whatever.
No, my lord. I bow down to your lordship.
Not no question of interference.
My lord, bow down to your lordship. There are thousands of till date cybercrime frauds, and the bank is never a party to it, my lord.
See, wrong or right, there are allegations against you.
My lord, this is a personal agenda.
How do I know?
Vengeance against me, my lord.
Says I'll conduct it right.
It's clear, my lord. Then the bank is involved in this. So how am I involved, my lord? How the bank is involved in this?
There are allegations, seriously.
Every bank has the right to do the advertisement, my lord. No, my lord. My lord may dispose it, my lord.
Huh?
My lord may dispose it on merit. My lord.
Dispose it. Give it to me. Give dictation. Yes. And unnecessarily, I'll have to write something on merit then.
My lord.
Yes. My lord, one line may be added, my lord. Though the state, both the cases made party, my lord, but no copy is not served. That may be.
Copy are not.
Once is case, then हम कुछ party कर देंगे. That may be. Item 2.
Major.
Your lordship kindly may be taken after research.
No, possible.
Otherwise, your lordship, my humble submission is to my humble commission is either your lordship with a kindly direction will be given to the court below to complete this procedure within a stipulated time period. As criminal proceeding is pending before this special judge SC/ST Valley, sir, in GRPS case number 38 of 2017.
When was the FIR?
FIR was lost. FIR was lost before Railway Police Valley, sir, in GRPS case number 38 of 2017, 27/10/2017. The lordship.
2017.
17. Till that.
What is the stage now?
Your it is in trial stage. And 4 number of witnesses already have been.
So advanced stage.
She's saying that the trial may be expedited, my lord. My lord, out of 14 witnesses, 4 witnesses examined.
Right. The petitioner is challenging the entire criminal prosecution initiated against him in the present proceeding. However, what is your name, madam?
On behalf of Jeenu Rani.
Huh?
Jeenu Rani Patnaik. Jeenu Rani Patnaik.
Yudani Patnaik, counsel for the petitioner, submits that
On behalf of Pikirat.
on behalf of
Kekiratha.
submits that there may be a direction for expeditious disposal of the trial. Mr. Raghuda appears for the state and submits that out of 14 charge sheeted witnesses, about 4 witnesses have already been examined. Therefore, the trial is proceeding as expected within proceeding in the expected phase. Be that as it may, his accused have constitutional right of speedy trial. It is expected that
Your
trial
lordship complainant is also not coming to the court.
trial court expected that the trial court should be able to see that the trial is concluded with expedition possible. With this observation, you will see. Yes, next.
Item 3.
My lord, last occasion, the petitioner and the opposite parties have been present before this honorable court and filed the joint affidavit. The long counsel for the state has been directed to obtain instruction whether they have been married or not.
Verified regarding the fact of marriage. The petitioner and opposite party number 3.
Or what happened in this case, my lord? I have taken instruction from the IAC. Though they have not married, my lord, no valid married, they have married before the notary public.
No, no.
Notary, no.
Notary, no.
And there were a customer.
Notary, no.
They not going to the Kaji, my lord, for solemnity as per their customer.
Original they will supply, but it is not.
What I was stated that.
Not notary.
But IO, whatever IO,
They
I am
IO
just.
said that.
I don't dispute my
Nikanama,
brother's
this is
content.
Nikanama.
Yes. Then go ahead. Before the.
Sani kon lekha hai give a proper. I can't read it.
This is not special. The special under
Since in the accused by lord,
they
have
I
not
proper.
police station and not given any anticipatory absence
Place it
rejected.
on record. Nikanama, please file it.
Yes, yes.
Party submits that they want to place on record the Nikanama between petitioner.
1 and 3.
Petitioner 1 and
Petitioner 1, OP number 3.
OP number 3. Let them do so within a week. That will copy. Yes.
So.
Page 4.
My lordship posted it to
Immediately after exemption.
immediately reopening.
Fine. Yes.
My lord, I stay of the further.
You are so everything is doubtful. Marriage is doubtful. Notary public and all this.
My lord,
I have given my lord
that judgment will pass on.
Yes.
Lordship do have. Lordship,
Two,
para 23 specifically I am referring to
205.
205.
Yes,
That-
Mr. Agarwal. Now,
He is agreeing. I discussed with him. I said, now the counsel for the ED is very fair enough, acceding to the judgment. Lordship, my play comes to
Otherwise also
that's
my lord.
para 23,
I am
para
always
23D. My case clearly comes on 23D.
D.
In case where the accused appears pursuant to a summons before the special court on a sufficient cause being shown, the special court can grant exemption from the personal appearance to the accused by the exercising power under section 205.
You file fresh application in the light of this judgment, it will be decided.
Well, only question would be, Lordship may direct, I will be simply furnishing that compliance of section 88, bond before the.
I will not say anything. I will simply say that I am setting aside the judgment, the order of 205 rejection and allow you to file a fresh application, and that same will be decided in the light of this.
Yes, right.
If you want, I can write to para 23.
23D.
D and
Your lordship, no, your lordship has to then
C and D.
C and D.
Right on. Right on. Petitioner is agreed by the order dated 14/3/2024 passed by legislations Khurda.
Your lordship may indicate para 33
30
because there are number of
23.
directions, my lord.
Yes.
23,
Para
23.
23.
In criminal miss PMLA case number 45 of 2022, whereby the application of the petitioner under section 205 CrPC.
Then, my lord, one more prayer. That in the meanwhile, the warrant has been issued.
I'll say the warrant.
That will not, in this judgment, Honorable Apex Court said he can file an application for cancellation of bailable. It's a bailable warrant. So you can
So, all
file.
right, I'll say, let him.
In this
Lordship,
judgment
Lordship
also,
may
it has
mention.
been also mentioned below. Your Lordship kindly see.
Lordship may mention.
It is neither here nor there. Either he will stay or I'll stay. How does it make sense?
Lordship may mention
It said that your Lordship
in the
kindly
event,
see
in the
page
event,
47.
Shall not be executed till.
Yeah, that you also,
Right.
this judgment has taken care of.
Yes.
shall not.
Sir. In the meantime, the Honorable Supreme Court in criminal appeal number so and so 13 law and direct application has settled the law insofar as maintainability of application under section 205 CrPC in a PML cases. PML. In view thereof, the petition counsel for the petitioner seeks to withdraw the petition to move a fresh application before the court below. If such application is moved, the same shall be considered in the light of the judgment Tarsim Shukra, particularly particularly on the basis of
Para 23D.
para 23 C and D.
No, your Lordship may indicate para, because there are a number of.
Para
23 below.
para
There are
20
a number of
in
directions.
view of
So
para
he is
20
to furnish a bond also.
Para
There are a
23.
number of directions.
para 23 of them. Mr. Mahabhatar, and counsel for the senior counsel for the petitioner submits that. Meanwhile, bailable warrants have been issued. In view thereof, in view of the aforementioned, the bailable warrant, the execution of bailable warrant issued on
8524.
8524 shall be kept in abeyance till the application, till the fresh application moved by the petitioner under section 205 CrPC is decided.
The Lordship may indicate the time to appear, because otherwise he will just file an application.
NDPS Mr. Agrawal submits that a fixed time should be granted to petitioner to appear before the court below and move the application.
अगर बूढ़ा लगा तीन जन जाकर बूढ़ा के कूद ना अवेलेबल हो कोई भी
Petitioners are directed to appear before the court below on or before 30th of June 2020.
Right.
And
Any
move
day.
appropriate application in accordance with.
My lord, the 498A when it was introduced, we are all panicky appearing for the.
Thereafter it will diluted.
My lord, after 5 years it diluted. Now this law, which was in fact come into existence 2012 onwards, because prior to 2012, whatever matters were coming to us.
And you know, in those FERA days, FERA cases were so serious. Now everybody forget.
Everybody. So
Thereafter
now
become famous like that.
I told him that last date, I told Gopal that this law is again going to have its own solution from the law itself.
He is relieved now.
No. He told me fairly. He told me, sir, I gave an opinion communicating to the director that in case there was no arrest when the 19 action not been taken, then normally the person appearing before the court should be allowed on bail. That was his fair submission.
I have given a written note to the headquarters below to consider this. That SPP should be instructed not to oppose the bail application where they have not arrested.
Right.
So that we can proceed.
Like when 41 A notice are given.
No,
if somebody
41, once someone is received, so
then you go and appear like.
Yes, no, my lord. The whole defense of the department till this day was CrPC is not at all.
I know.
And the whole thing, if you read the law, constantly they are saying in the event of this CrPC to be followed. The presiding officer to be CrPC to be followed. 439 CrPC to be followed. Everywhere the section, the law itself
it's what it was not that CrPC is not applicable.
That is the view.
CrPC is applicable. No, I have never submitted CrPC.
No, not you.
Because of section 45 below, there is a bar. Otherwise, CrPC is applicable.
Now somehow this judgment is clarified.
Very clear.
Yes.
Here also, my lord, conduct of the accused has to be seen. They have given number of directions. Suppose an accused has appeared 6 years back, going on taking time, whether this judgment will applicable or not.
No,
So there are number of
those things will be fine-tuned.
Yes,
Yes. Depending upon case.
But in the present case,
What
like
your conduct, you are
serious case,
rightly
that is not
saying, your conduct you have to see. 205 is not meant to misuse.
Yes, my lord.
Misuse.
And that's why they said he must give a bond. Thereafter, file an application for exemption. First is to give a bond.
Give a bond. assuring the court that I'll keep on appearing. That's the idea.
Very purpose is the trial can be concluded early.
That's the idea. That's the whole idea. Not that you don't come at all.
So that fair
First you
provision.
come, give a bond saying that I'll keep on appearing or through counsel. Thereafter move on.
Any day I have a problem, I'll file application that is to be allowed by the court. But not that blanket exemption is to be granted.
That was okay. Thank you.
Item 5.
Compromise. 6. Yes, sir.
Item 6, my lord. I am challenging the order of cognizance, my lord, for commission of offence under section 341, 323, 506, and 34 IPC, my lords, on the ground that matter was amicably settled between the informed and the present petitioners, my lords.
Where are they? Are they coming today?
No, they are not coming today.
No FR, no charge sheet.
No charge sheet, nothing.
This is the certified copy of the FR.
So don't throw it like this.
My lords, my lords. I have also filed the
Counsel for the petitioner seeks an adjournment to place on record additional documents and additional documents. He may do so within a week, 1 week. He also submits that the parties have meanwhile settled the dispute. Let the party appear before the court on the next date of hearing, immediately after the Yes, next.
miscase for stay of further petition.
You don't file the petition properly, you
I
throw 2
filed
pages.
the certified copy of the cognizance order, my lord.
No. If it is compromised, what is the big deal?
Yes, my lords.
And
Issue notice to the opposite
Yes,
party.
I have
Number 2, I have
issue notice to opposite party.
party number 2 and date may be fixed, my lord.
Issue notice and date fix. Yes, next. 7th.
Item 7.
My lord, both are doctors actually, they were working in PSC Saranpur. There was some rift between them. Now they have realized they have given affidavit that they are the case.
Hey, what is the offense?
Actually, while they were working, there was some quarrel between them. Therefore, though, there was some misunderstanding and now they are realized. One is my daughter-in-law, another is madam's niece. Kali.
Okay, you have.
Tomorrow, I'll call them.
I will say. Oh, sure. Take it. They are related somehow.
Yes, ma'am.
Okay, call them tomorrow. Huh? It's the first item. It's first item. Bring them with close.
Item 8.
Hey, can you bring them at 2 o'clock? Virtually नहीं आसु दुकान
First hour.
काली बहुत टफ रहेगा सेठी पे हमको
First hour नहीं आसी.
नहीं first hour तो नहीं आसी यदि if you can
Affidavit दे दीजिए.
if you can bring it today even at 4 o'clock at any time I'll take it up. Try. We'll finish it up today. Online let them appear.
Hostel जान करो. Comfortably. सरकार चेक दस. No, सरकार चेक काली first hour sir.
बहुत प्रेशर होती है.
Join कर जुएड ना. First hour में देख.
2 minutes, 500 matters into 2 minutes. How much?
No, okay.
Yes.
Item 8.
Bring tomorrow. Yes.
Arjun Malad thrice non-appearance.
The matter was listed on 11/1/2024, 4/3/2024, and 1/5/2024.
Specifically urgent to today.
Nobody appeared for the petitioner. On the last date of hearing, it was made clear that no further adjournment shall be given. In view thereof, it appears that the petitioner is not interested to prosecute the matter, hence dismissed.
Item 12.
Alert from the last occasion, Malas had directed both the parties to appear, Malas. The petitioner is on the way.
I have not directed. You might have said that, but
No,
if
Malas,
it's settled.
already it is compromised. Nothing is remaining in the matter, Malas.
Only the matter is the criminal case is not first, my lord, the petitioner will be prejudiced as he is a government servant. He has also got a departmental proceeding in his name because of this.
Who is he? Samir Kumar Behra is the husband.
No. Samir Kumar Behra is not the husband. He is the outsider one.
Husband, my lord, husband.
Husband or Sango again.
Sangu kala Sangu baha pe notary kari baha kala Sangu. Sangu naro opponent.
ବହୁତ ଭଲ କାମ କରୁଛନ୍ତି ନୋଟରୀ ବାହା କରେଇଲେ ଆଉ କଣ what to do you are working as
I am a fireman.
is there any chance of settlement between them no
Settlement ହେଇ ଯାଇଛି ଆଜ୍ଞା already.
କାହିଁ ଦେଖନ୍ତୁ
ଆଜ୍ଞା annex
and
annexure 3 ଆଜ୍ଞା.
Nivedita Tripathi
Aଜ୍ଞା.
has married to whom
That Ponda.
who is your friend
Yes, mother.
who is your friend
Meena Katra Panda.
Meena Ketan Ponda again.
you are the instrumental in making them
Exactly.
together now they have settled na where is that can you show me
मतलब जो FIR टा जो पे हितला से already it is compromised.
show me something
मतलब annexure 3 page 21.
mediation
Yes, mother. Page 22 is the final order.
Oh, ABL पहले देते
Again.
why have you paid 4,50,000 you paid 4,50,000 to the informant Nivedita
Yes, my lords.
Huh?
I had to pay for the compromise.
you paid 4 lakh
4,50,000.
very unfortunate where are they
My lord, the petition is on the way actually due to that rally.
to 4 o'clock 12 o'clock I think.
My lords, the OP number 2 didn't come. That's why I pray before my lords to issue
Right,
notice, my lord.
the parties have settled the dispute through mediation and mediation report is placed on record as annexure 3 to this petition. It appears that the present petitioner has paid 4,50,000 to the opposite party number 2 to settle the dispute. Notice has not been issued.
No.
Issue notice to opposite party number 2. In the meantime, proceeding before further proceeding so and so states. Yes.
My lord, sir, date may kindly be fixed.
Date will be yes. Further proceeding state. Yes.
13.
May I please, my lord? Lords, petitioner challenges the cognizance, my lords. Petitioner is a lady and cognizance has been taken against her for an offence under section 354A and 354B, my lords. The background of the case is, my lords, the petitioner works on the capacity of an operational executive of the said bank where the complainant herself was also an employee. And it is stated and narrated in the FIR and so also all throughout the statements, my lords, that the present petitioner, the lady, my lords, that Padmavati Biswal, was asked by the branch manager Hon'Ble and Ondia. The branch manager asked her to ask the complainant, that is complainant, to stay in the office. She just asked her that the branch manager has asked you to stay in the office.
You help, simply say you help the branch manager who is committed.
No, my lords. Thereafter, another accused person, that is Jyotirmay Mandal, who is not the branch manager, my lords. It is alleged that person entered and outraged her modesty. I was not present in this scene. No further complicity, my
But it
lord.
is only cognizance.
Lords, and the petitioner is a lady and is in advance
Let us see.
advanced stage of again. And I have arrayed her as OP number 2, my lords, the informant. And moreover, the petitioner is pregnant and in advanced stage of pregnancy, my lords.
What is the only cognizance has been taken? Nothing is going to happen. I am issuing notice.
My lords.
I will issue notice. Let us
Lords.
immediately after vacation. 19.
Can I pray, my lords, stay of further proceeding?
Cognizance is only taken.
My
What
lords,
is happening now?
If she will be summoned.
Is there any coercive process issue?
No, my lords. So we were under 41 protection. But
then
if summons are to be issued, she is in advanced stage of pregnancy.
It's all right. You immediately move the application. I'll stay. Issue notice.
Yeah.
You have not filed any document to show that she is pregnant.
The
Everything in, you took last time to file documents.
I filed the.
But once you make a statement, there should be something on the
Supported by.
record.
I entirely consider with my lords, but.
Then, everything in the air. And you want to stay. While making statement, be responsible.
Lords.
If you file application, why have you not said the pregnancy has not taken place yesterday?
No, lords, that
Then,
cannot. Naturally,
when have you
cannot
filed
be.
the petition?
Petition has been filed since long.
That time she was pregnant?
My lords.
So why have you not written?
Lords, the latches of the council shall not bear upon the.
No.
Lords. Admittedly, that is a latch on my side, my lords.
Then
I
you
admit
have
it,
to
my lords.
suffer. I can't grant stay on the basis of something you submit an
Vacation
error.
ensues.
Tomorrow she will come that I will never married.
We have a
What to
vacation.
talk about
ensuing-
pregnant?
My lords,
The other side will come and say that I will not even married.
my lords, vacation is ensuing since day after
That's
tomorrow, my
the whole
lords.
difficulty.
Lord, may pass usual order.
Right down. Item 13, na?
My lords.
Counsel for the petitioner submits that the petitioner is a lady and entangled in a case under section entangled in a case where offences are alleged under section 354 capital A, 354 B, 109 and 34. The petitioner is at an advanced stage of pregnancy and he apprehends that if the process of the court is issued, she even can't appear before the court. In that view of the matter, further proceeding in so and so is stayed till next date of hearing.
Much obliged.
But you write all these things. Don't do that.
I'm sorry.
Today the vacation is ensuing. Therefore, if anything happens, then the problematic. Yes.
Item 15.
15. 15. 15. Non-ABS for the petitioner in the interest of justice. Last time we yes no.
Specific urgent. Non-appreciate.
Next time. Vitara kori tapre dismiss. 16.
16.
Yes.
May I please, my lord. My lord.
Good.
My lord's blessings. The matter is settled between the parties. 16 and 56 may kindly taken out together.
16 and
56.
Yes.
16 is for recall of PW. And in the meantime, the victim has married to the person and victim is
60.
No, 16 sangre 56.
56. 56 रे कौन अच्छी? 56 is what?
56 for quashing a proceeding on the ground of compromise.
Okay.
Offense 376.
Where are they?
6 Poksho.
Where are they?
Also kindly say. Last, also kindly say.
Petitioner and opposite party to are present in the court and being aggravated the respective counsel, they have also in view of both the fact that the parties have settled the dispute and matter is sub judice before this court to further proceedings also. No, why can't they come today? I have not exempted.
Tomorrow.
No course action.
No course action is there after immediately after vacation. Immediately after. You have to bring because I don't know whether they are survived today or not.
Yes, sir.
If I would have exempted, I can understand.
Yes, sir.
Not exempted. Yes.
Tomorrow,
Covered by Rosalind, you will go.
Yes,
I
sir.
should have brought them today.
Tomorrow,
Tomorrow may not be possible.
Yes,
How much?
date.
No course action.
No course action. Yes.
Item 19.
My lord, this is a case offense under section 466, 468, 409, 34 IPC.
Yes.
The petitioner filed a discharge petition that was rejected. That is at Annexure 3, starting running phase 59. The petitioner, Loknath Pradhan, he was the principal of that Devagad College. Money sanctioned for construction of the building. Vidyot Telibeni supplied cement, supplied rod. 78,300 was also
as per the record, petitioner sanctioned, but that was not paid to that video. Video, after retirement of the petitioner, 7 months of his retirement, video issued a letter to the college that block has not received 78,300. On getting that letter, petitioner issued a letter to the video that kindly wait, I am inquiring into the matter since I am retired. If it is not paid, I will pay. That check was paid to Gita Traders, which the petitioner sanctioned. Who has manipulated that? That was not taken, investigation has not carried out. After retirement, this case has been initiated. Petitioner filed application to discharge. That was rejected. The petitioner also ready. Can record kariya scope nahi. Se sanction karichi. Record maintain nahi. Kintu check payment he chanelo. Gita Trader.
Check sheet.
Ye clerical staff come karthibe.
That's
why the petitioner.
That is the area of investigation.
My lord. But the petitioner, before registration of the FIR, wrote a letter to the video that is at page 44.
So that may be a preemptory action.
That is also in the record, part of the record.
That may be a preemptory action on your part.
2324 my case adjourned to 2324 my lord. For framing of charge my lord. Charge
not charge.
Charge application is moved, rejected.
Moved, that was rejected. Posted thila hey nahi since this case is filed.
There is no question of settlement also.
No, settlement ye petitioner raji achi paisa ta de do boli.
Who is the informant?
Informant is the police.
Police.
Basing upon that letter, police registered the case.
Where is the charge sheet?
Charge sheet, my lord. Running page 26.
How many witnesses are there? Charge sheet witness.
12 witnesses.
14.
Sorry, 14 witnesses. The petitioner is 77 years, retired since long. After 7 months of his
the allegations are there. How to get out?
There are allegations, madam.
Only 78,300 rupees.
Not the amount is not more important.
But police has not investigated who has forged the.
So these you have crossed that stage.
Right.
Now cognizance is taken, your application rejected.
And
I'm only looking at the one aspect by can we expedite the trial? That's the only relief it seems to be. Nothing else. I'll just put it immediately after vacation. Let us see. Immediately. Issue notice to you should have.
And if the adjourned petition will file, that may be considered. That.
I don't stall the premise. Wait, if the charge is framed, then I'll expedite the trial.
Frame hey more application in process. Only
but I'm looking at expediting the trial. I will not interfere in this.
Charge frame will be
don't stall it. Better charge frame will have change criminal revision file and tag simply issue notice. We will see. Yes.
CD call for notice.
TD call for
state only party.
TD call for issue notice. CD call. Yes.
21.
Yes. 20. 20 kona. 20.
21. I missed.
20. Yes.
This is a case under section 498, 304B, 302, 34, and 4 of DP Act. Here what happened, the present petitioner, the petition number 1 is the mother-in-law, and petition number 2 and 3 are sister-in-laws of the deceased Millard. Here this is in this case, the deceased died after 9 years of her marriage, and thereafter the informant who is the father lost the affair that died due to burning Millard after 9 years of the marriage. Informant lost the affair against the husband and in-laws member, and all the allegations are omnibus in nature. Millard. Thereafter, Millard, after investigation, police submitted charge sheet against the husband, keeping the investigation open, and initially no charge sheet was filed against these petitioners. And thereafter, Millard, the case of the husband was committed to the Millard trial court, and there the learned trial court, after examining the witnesses, has acquitted the husband Millard. Here, Millard, the judgment is at annexer.
Yes, there are you are absconding.
We are absconding. Thereafter, subsequently, supplementary charge sheet was filed against us, Miller, against the mother-in-law.
Offense under
Same offense.
304.
Yes, Miller. And on that ground, Miller.
Anytime what happens, husband may not be there. The mother-in-law,
No,
father-in-law.
here, Miller. Here is the case.
I'm
Refreshing. Here is the case. I have filed all the deposition copies, all the Miller judgment copies, and others, Miller. And it is not a case that the husband was not there, Miller. It is a case where husband was there.
But I am not going to see the evidences and try.
Your Lordship, on the last occasion, directed me to give the deposition copies. So I have filed the deposition copy and judgment, Miller. Here, Miller. So my Miller submission is, Miller. This is, Miller. Will be.
I will expedite the trial.
Miller, we are absconding and NBW has been issued. What happened here, Miller?
I'll stay the NBW.
There is every chance of acquittal, Miller. And all the petitioners are ladies.
Therefore, you go and face it. But 304B, na?
Like it 100%. 100% burn injuries.
Yes, Miller.
And whose instance nobody knows.
Your Lordship, kindly see page 52.
52, huh?
Yes.
Judgment.
Yes.
Lordship, got it?
Yes.
Last 4 lines, your Lordship.
1 minute. 1 minute. 1 minute. 58, huh?
52. 52.
52, yes. Now.
Last 4 lines.
Scanning.
Now scanning on the evidence, starting, Miller.
Yes.
Last 4 lines.
Yes.
Last 4 lines, your Lordship.
Further, the informant in cross-examination in para 9 has deposed that he had not made any complaint.
No, further there is no evidence. Lordship. The word started.
Further, there is no evidence to establish that the accused was present at the time of incident, soon before the incident and after the incident near the beach.
Yes, there is no evidence. So he was acquitted.
So therefore, the acquittal is because the husband was not present.
That does not
whether
mean,
you people were there or not, I don't know.
No, that does not mean that husband was not there, Miller. There is no evidence to establish that the
Anyway,
accused
that was the ground of acquittal.
Yes.
I'll stay the NBW issued against you and till 30th of June and go and appear. I'll expedite the trial.
Appear and release on bail unless, Miller, ladies, all ladies, Miller, all ladies. Your Lordship may kindly
record that out. Right down.
And on the ground,
but I can't grant bail. See, this is 482 court. If I can't,
your Lordship may direct for surrender.
I can't take over the jurisdiction of the trial court and grant you.
No, I have a small prayer. Your Lordship directed for surrender, and the
and I'll record
bail court will consider on the,
yes, that I am going to do.
The main principal accused was
right. That I'll do. Right now. The petitioner has challenged the entire criminal prosecution initiated against. How many of you are there?
3, Miller.
Against them in the FIR number 2. The criminal control petition submits that initially the charge sheet was filed against the husband of the deceased, and he was subjected to trial. While judgment dated 8/8/2023. The learned additional sessions Judge Kodola, while the judgment dated 8/8 in ST case number 148 of 2020 has acquitted the husband. Petitioners are the in-laws of the deceased. In-laws of
ladies, Miller.
And they are petitioner number 1 is
mother-in-law. Petitioner number 2 and 3 are sister-in-law,
married sister-in-law, and petitioner number 3 is petitioner number 2 and 3 are married sister-in-law of the deceased. Consequently, the petitioner submits that in view of the fact that the main accused, the principal accused, that the husband of the deceased has already been acquitted. The benefit of that judgment can be extended to the present petitioner. By way of supplementary charges, the petitioners have been implicated in the present case. The petitioners admittedly petitioners are admittedly absconding. Therefore, I am not inclined to interfere in this matter. However, I grant liberty to the prisoner to appear before the court and seek remedy available them under law. Under law. The petitioners are directed to appear before the court on or before 30th of June 2024 and move appropriate application before the court below and also participating in the trial. If any such application is moved for any the council of the petitioner submits that all the petitioners are lady members, lady member, and the principal in the case has already been acquitted. Therefore, the petitioners are entitled to grant of leave. Grant of leave. The petitioners are at liberty to raise all these points before the court below at the time of hearing of the application. Taking into consideration the fact that the petitioners are lady member of the family, and the principal has already been acquitted. I am of the considered view that if the petitioners surrender and cooperate with the trial, the trial court should do well to see that the trial is expeditiously trial is concluded in piece of the yes.
Well.
Yes.
21. My lord, only opposite part number 2 has been appeared, and the rest opposite part number 3 to 7 have not been appeared, my lord, because the notice has not been issued to them, my lord.
Notice awaiting service.
Copy. I am appealing for on the opinion number 2. They have not solved the copy.
My lord, I will serve, my lord.
And the elder lordship in this case, particular case, lordship, and this honorable cause I directed to trial will conclude a period of the 9 months. That order has been passed, lordship. Age is 6 request, lordship. That order.
Who is passed that order? I have not passed.
No,
that is different matter.
In another case.
My lord, CRLMP matter.
Have you disclosed that CRLMP here?
No, my lord.
किसी disclose करना.
This is the matter is different, my lord.
Same FIR.
Same FIR, but
matter may be different. In some court has passed an order for expedite disposal of the trials.
Right.
And you conceal that.
My lord, I am the informant, and I made the deposition before the para 3. Sorry, my lord. My lord, I have made my deposition in para 3 of the exemption in chief by saying himself that he does not want to proceed further in this case. And in para 2 of the, he has.
I am asking something, you are going somewhere else.
My lord.
If some petition is pending before this court and there is an order already passed, why have you not disclosed that?
Yes.
That's what I am asking.
My lord, I am challenging the order of the
whatever you do.
311 petition, my lord.
Whatever be, maybe. Why are you not disclosing that this petition is pending? And there is a direction for conclusion of trial within 9 months or whatever.
My lord,
and these petition, your lordship, mechanism surprisingly, the accused have come up before a lordship challenging the recall petition. When the magistrate has considered that it is essential for recalling P22, and P22 is the accused, and accused has filed this application, why I am recalled?
My lord, I am petitioner is a senior citizen, my lord. He does not want to proceed with the case, my lord. But one of the accused has filed the petition under section 311 for recall of the witness, my lord.
In this case, the informant is a professional litigant and having now 27 number of cases, criminal cases against the present petitioner, and also numbers of CRM cases are filed before this honorable lordship. And lordship, in this case, lordship actually has filed. In this case, lordship, in order has been passed, lordship.
And 2 to 7 are the accused.
My lord.
Yes, lordship.
They have not been appeared, my lord. Notice has been not issued, my lord.
Why should they appear? I don't know.
What was the order? Where is that order?
Yes,
Sir, Lordship,
My lord.
Lordship, in
Annexure 5, my lord, impugned order, my lord.
Yes.
Lordship, I am submitting
My lord.
the order, one order, lower court order, Lordship, and date and fixed, Lordship, at 2023. Accused person is absent, I got allowed to be repented under the CrPC for today only. No witnesses today. Issue summon to the CS witness pitching on 2023 for trial. In the meantime, Lordship, very cunningly, the informant what it says, Lordship, in 2023, and thus the put up on today being advanced by APP filed Hajira one witness. He is examined, cross examined and discharged of PW2. And lots of date was fixed for 30. And he has before 13th, last we have advanced this record and informed and give the deposition. And the accuser filed a recall petition for the cross examination because accused persons they have intentionally number of cases, and that report police has submitted the report, Lordship. And what police has submitted the report,
Who is PW2? Who is PW2?
PW2 the informant. They have filed the petition, Lordship. And accusers filed the recall petition for cross examination because they have not court has not trial court not given the opportunity for the cross examination. That's why, Lordship, the accusers filed the petition for cross examination to the informant, Lordship. And that order they have.
My lord, kindly see the page 21 of the annexure 3, my lord.
Allowed and they have challenged this order, Lordship.
My lord, page 21 annexure 3, para 3. At present, I do not want to proceed further in this case, my lord. The petitioner himself deposed before the magistrate, my lord.
Magistrate. Examination by the defense lawyer. I was not examined by the police in this case.
Sir. Please, sir.
Examination. Hey, but just see, come to page 20. This witness who has been recalled, he has not been examination chief is also not there properly. 3-line examination chief.
Because
I am not the informant in this case.
Because the accused has not cross examination to the informant, Lordship.
But he says that I am not the informant in this case. I know all the accused persons in the case. They are my due to certain trivial dispute. I filed this complaint against.
Lordship, in this case, Lordship, informant is filed a recall petition. Informant, the trial court, the informant. Now the present petition in this case, Lordship. And
I understand the informant is now sought to be recalled by the accused. Just see the page 20. Page 20 of this petition.
Because they have not supplied the petition copy.
Have you seen, Mr. Maharaja?
Yes, sir.
Deposition dated 17/11/2023 of PW2. In the examination in chief, the said witness, namely the petitioner, has categorically stated that the matter has already been settled, and he doesn't want to proceed against the petitioner. Therefore, the defense lawyer put only cross-examine the said witness by putting a singular question, namely, and the same question was replied by the witness, saying that I was not examined by the police in this case. Since the present petitioner, namely the PW2 in the case, has not supported the prosecution. Indeed, the prosecution is agreed in this case. However, surprisingly, the petitioners, surprisingly, the accused persons have moved application under 311 CrPC seeking recall of this witness. It appears that the said application was moved by the accused person to settle the scores, with the opposite party, settle the scores with the petitioner, as the petitioner appears to be a chronic litigant. In that view of the matter, I'm not. I'm inclined to set aside the order dated so and so. Set aside the order dated. Once order by.
I will try to.
Which
Counter affidavit, Lordship.
Order dated 18/1/2024.
18/1/2022.
Lordship, I have not given the
Passed
opportunity
by-
to cross-examine, Lordship. And that is the order sheet, Lordship.
Passed by-
Order sheet I am showing,
Passed
Lordship.
by JMFCO Bhubaneswar. So, annexer, which annexer is that?
Annexure 5, my lord.
5, annexer 5.
Lordship, I have not given the opportunity. I filed
My lord,
the
due to
counter,
personal
Lordship.
interest and
No,
vested interest,
Lordship,
my
I
lord.
have not given-
Professional interest is
Lordship, I
to.
have not given the opportunity,
I
Lordship.
passed the
Lordship,
I understood
I-
it now. I passed it.
Lordship, I submitted the order sheet, Lordship. And whatever Lordship, order sheet is stated, Lordship. And
When,
they don't
when
give-
you answer me one question. When can you recall a witness?
Because defense having no giving opportunity to cross-examine.
If the witness have not said anything against you, rather he says that I have settled the dispute with
Because I
you.
will be ready to.
Can you recall him?
Yes, Lordship.
And to ask him, no, you have not settled with me.
No, because there is a giving to that much.
Professional interest, my lord.
Criminal law, Lordship, there is a giving opportunity to the accused, Lordship, to cross-examine.
That's not the law. Sorry.
That is the cross-examine.
That's not the law, sir.
Like one-
If Mr. Maharaja would have said that they are handing glove and he's I can understand. Who are you to ask?
କାଲି ମୋ ନାଁରେ ଜଣେ କେସ୍ ଦବ ମୁଁ ଆରେଷ୍ଟ ହେବି ତାପରେ ଆସି କହିବ ପହରଦିନ ଆସି କହିବ ଆଜ୍ଞା କମ୍ପ୍ରୋମାଇଜ ହେଇଗଲା
ଠିକ ହେଲା ଭଲ ହେଲା
ନାଇଁ ମୁଁ because I will ready to bear the jail because I will cross examine Lordship.
That's not
Because I will file the counter affidavit. I will file the counter
that's
affidavit.
not the idea of 311.
No, because there is no giving opportunity to cross examine because
For that,
I have not.
if you think that one minute, if you think that you have been wrongly prosecuted by him, the law is you can proceed against him by filing a malicious prosecution suit. You file a suit against him that wrongly he has prosecuted and subjected me to the ordeal of trial and prosecute. File a suit.
Because why? Because they have admitted I have the compromise because I have no compromise. ମୁଁ compromise ଜାଣିନି କୋଉଠି compromise କଣ ହେଲା ମୁଁ ତ compromise ହେଇନି.
You will be acquitted now.
ମୋର 30 ତାରିଖ
You will be acquitted now. In view of his statement, you are going to be acquitted. If you are acquitted, then you have an option of filing a suit for malicious prosecution. Do you know that?
No, because
why are you unnecessarily wasting your time?
They have mentioned compromise. I have compromised this matter. I will file the counter lawsuit. File the counter lawsuit.
Tomorrow. I'll just come. I
will file the counter lawsuit.
Yes. I don't know.
Anyway, you give it, I'll just see whatever. Yes. I'll just see what can be done. I have dictated. Yes, item 22.
Compromise matter, sir.
Compromise. Item 22, you were saying something. Yes. Tomorrow not possible. How much time? See, we can't keep on waiting for the accused. Yes. They may have 1,000 inconvenience. We have also inconvenience. No. Tomorrow morning. So I have given you 3-4 opportunity.
3-4.
You said I'll call them today, tomorrow, and all. You don't call. We can't wait for the accused for such a long time. No. We see, try to appreciate. We are under. See, the court is not under their mercy. I have accommodated you thrice. Tomorrow not be possible. Sir. Just see, tomorrow is a lot of work. Last working day, how is it possible?
In between, you made the injured Pinku Samal as a party and informant husband.
Seen it now.
Informant husband as a party.
ହେଇପାରିବନି ନା କାଲି ହେଇପାରିବନି କାଲି କେମିତି ହବ କହୁନାହାନ୍ତି କେତେ ମେଟର ଅଛି କାଲି ଦେଖୁନାହାନ୍ତି possible last day na how much indulgence I have given you every time you say that I'll bring him I am not waiting for the accused to come and if some invitation is to be printed you tell me so I will print invitation and give you with due respect, we will call them to the court. What is this? Let it come. Immediately after vacation. First day of vacation. 19th of the year. Assignment quad paleo. Yes.
Item 5. Good afternoon, Your Lordship. I'm appearing here on BC. On behalf of the state informant. On last occasion, this honorable court had directed the accused to be present at the court.
Yes, sir.
By virtue of the joint affidavit filed by
376. Yes. ଦେଖନ୍ତୁ କଣ ହେଇଛି file counter.
Counter no instruction like.
To seek instruction. Instruction. Because for the petition submit that when the matter is listed
Tomorrow, thereafter
matter is posted in the recent future before the court below therefore he seeks an interim order in view of the fact that the summary petition is entering. Therefore, the petitioner is given liberty to move application before the court below, seeking an adjournment, owing to the fact that matter is submitted before the court.
And keeping in mind the date fixed by this court. Date fixed by this court.
Date fixed for the
28th.
You move application.
28th June.
Yes. Yes.
24.
No pass over today.
How going to pass over?
Today, no question of pass over. At the request of when possible.
498 notice. 498.
Issue notice to opposite party number. Written about. Yes. I issue notice on I also. Yes.
25.
One was a excellent case, one is also passport for police FIR. Now
there are two cases.
Yes, one was a excellent. Two cases in the criminal case filed also. Passport was also a police case FIR is not before the police station. Police is now need the petition for the Procedural service. Now this case is continued. But their case is already continuous. Again, the same problem file a complaint case against me.
166 of 2004.
So my estimation of section 210 of the CrPC is not being followed the procedure illegality. So 210 CrPC categorically stated that if there is a political complaint case and that complaint is brought to the notice to the law to market the yes there is a police case. The market first the proceedings of the 166 cases for the contrary report. And after a second the report we found yes when the one for the election to be referred same specification same complaint. Then both the cases tell that they illegal into culture. Now if a complaint case is filed meaning that the police has not been made the attacks before the illegal other parties there. So accordingly complaint case is filed. So my estimate solution is also if there is a new thing has been case and police investigation going on. And 210 has been followed and the market has been forwarded the same complaint to the concerned police station.
Where is the FIR? How do you say that both the cases are same? Yes. 1 minute.
Procedure, no wrong procedure is followed. Not even the case has turned to a last stage. It's just a complaint case has been filed. No order has been passed. So this is not.
Why don't you move application before the court?
Applicable this case.
No, where have you? Where have you moved the application? You tell me.
My lawyer can certain that nothing has been happened and summons has been issued in the complaint.
Why can't you won't move application?
Say automatically that is the procedure 10 to
210 application you can move.
210 also because when the complaint same applicant the complaint is all. The yes, I have already lodged an FIR before the police.
I understand. You are absolutely correct. Lekin why can't you go to the court of first instance where straight away 482? I will give you at liberty.
You
so
let me.
210
You move application.
No problem is there.
I should go for one for the question two of
I don't know. You have to move application.
Because my lord, there are various different offences are there.
That is then the counsel for the petitioner submits that for the same cause of action. PS case number 135 of 2023 it has been registered against the petitioner and investigation is going on. Investigation is going on. When the matter stood thus, the complainant has filed the ICC case number 6 of 2024, 6 of 24. In which the land court below has issued summons. Mr. Journal, land counsel for the petitioner submits that before issuance of summons, the trial court ought to have followed the procedure contemplated under section 210 state here. CRPC. I'm not going into the merits of the case at this stage. However, I grant liberty to the petitioner to move appropriate application before the court below under section 210 CrPC. If such application is moved, the same shall be considered
on its own merit.
And till the application, till such application is decided on its own merit, the summon issued by the court below against the petitioner shall be kept in abeyance. Yes. Go move application. It will be rejected again. Again it will come. On its own merit, let it be. Yeah. 24 is over, long way.
Notice issue. 498 notice is.
Yes, next. 28. Nothing will happen. Nothing will happen immediately after a case. Yes. Yes. 28. Yes. Compromise matter, where are they? You say it is compromise and you notice. What is this? Matrimonial dispute. Then if you have settled, you have to settle the dispute. Compromise. Notice gole compromise. तो कौन compromise
ये कोई करना थी पेज 24 ये लॉस में काइंड से
हाँ।
पेज 24
कौन हला
13B of the Hindu Marriage Act has been allowed marriage between the parties dissolved by a decree of divorce.
Write down issue notice to
Yes.
opposite party number 2, written evidence also. The parties have settled the dispute, which dispute, the dispute is arising out of mutual dispute, and the petitioner number 1 and opposite party number
Opposite party number 2
have applied, had already applied for dissolution of marriage by mutual consent, which has been allowed.
Yes, yes.
Which has been allowed by the order dated 24/1/2019
Yes.
by the family court Bhadrak. Bhadrak. The issue notice so. In the meantime, the proceeding before so state. Yes. 29.
With the lordship. My lord, I am challenging the impugned order dated 19/2/2024 passed by the special judge Baleswar in connection with special case number 298 of 2023 lordship. In that case, as per the annexure 5, there was a 167 support to petition was filed. And that was rejected by the special judge on 19th February 2024. My lord, the case in hand, the FIR was registered under section 20B(c) of the NDPS Act.
When the charge sheet was filed, after how many days?
My lord, charge sheet was not filed.
Your lordship, there is no irregularity, no illegality. I will turn to you I want to draw your lordship kind attention. Many bail application what minute don't again
167(2).
No, Johnny, sir, I am confirmed. Many bail applications so far, including the petitioner, is pending for consideration before this honorable court. And that whether that ground has taken or not, I don't know. But
whether charge sheet is filed within time or not?
Not charge sheet till today, charge sheet has not been filed because 125 days. Bartaman 125 days. 180 days jagare 125 days kai charge sheet file karibe?
My lord, I may be permitted, my lord. My lord, I may be permitted to.
Again, देखो ना page.
You are confident that they will not file.
Page 25. Page 25 will also make entry.
I may be permitted, my lord, to draw the attention of your honor. Whether I fairly admitted that in case of the commercial quantity, there is a specific statute is 180 days, which may extend to up to 1 year. That is the section 36 of clause 4. But now the question is that when there is a three separate seizure list has been prepared, from 3 different persons, my lord. My lord, 3 different seizure list has been prepared. One seizure list has been prepared on the 17/11.
The trial court at page 25 says that only it is 125 days.
Yes.
And there is the question of 167(2).
Yes, my lord. Yes, my lord.
Total 42 kg. My friend, yes, I understand. Total 42 kg. My friend says that there are 3 accused persons. So separate seizure has been made. So for me is concerned, it should be completed.
What is the stage now? Now charge sheet is filed. This was in February.
This was in February.
Charge sheet is already been filed. My lord, I don't want.
Where is the question of 160?
160. My lord, I may be permitted. I just want to draw the attention. Mere registration of the case. Mere registration of the case in non-bailable offence is not a ground to deny the bail or your honor to settle question of the law. The prior passage is to be satisfied, your honor, whether if the seizure has been made, 12 kg of the contraband article has been seized from the possession of the petitioner. How the offence under section 20B(c) will be attracted, your honor? When the Amendment Act came in 9 of 2001, serial number 55, it has been clearly specified that the 20 kg, more than 20 kg is coming under the commercial quantity. When 3 different seizure lists has been prepared from 3 different persons, how one case is to be registered?
Case is one. My friend.
Prosecutor, I just want to draw the attention over the settled question of the law. I just draw the attention of your. I want to cite the decisions in the case of Upendra Kumar Sahu versus Giridhari Sahu, which was reported in 1996 volume 82 CLT 7631.
ମୁଁ ଏ ଜଜମେଣ୍ଟ ସବୁ ଯାକ ଦେଖିଛି ଆପଣ ଖାଲି ଗୋଟେ ପଏଣ୍ଟ ବାହାର କରନ୍ତୁ କୋଉଟା ଏଟା ଆପ୍ଲିକେବଲ ହଉଛି
1 minute let him argue For his satisfaction. Yes, yes. Which judgment you are talking about?
1996, volume 82 CLT 763, Lordship.
What is the ratio?
Ratio, my lord, mere registration of the case in the non-bailable offence is not considered. The court is to be considered about and satisfied about the prima facie of the case. Another decisions of our own High Court, Lordship, that was reported in 2014, volume 57, OCR 812, Pradipta Raut versus State of Odisha.
Yes.
On the prosecution, partly to prove that the contraband article were seized from the exclusion and conscious possession of the accused. My lord, the case in hand, how much contraband article has been seized from each of the petitioner? If there are
These judgments will not help you. Better you withdraw this petition and to raise all these points at the stage of your application for regular bail.
My lord, I fairly agree with the submission of the public prosecutor. If there is one single issue you are prepared, so 180 days is to be counted. But when there are 3 single issues was prepared.
Okay, thank you. To withdraw this petition to argue all the points before the court below while his bail application, regular bail application is being heard. This will go to yes. Next. 30. No, very good. 31.
Yes. Previously, you have also heard this matter. My lord, in this case, my lord, the police filed a charge sheet against 10 persons. Out of 10, my lord, 3 persons faced in the past trial and 6
NBW is issued against you.
NBW issued.
You won't appear before.
My lord, because the matter is pending before the learned SPJ. If I appeared, he will be committed the matter and custody will be.
Then what can I do? I will pass an injunction order.
Your lordship, what happened? Your lordship may kindly consider. Here the 3.
Are you arguing a bail petition or arguing NBW cancellation?
My lord, my another prayer is there, my lord, passing of the proceeding. Because why, my lord? In this case, my lord, the learned court below passed order under 232 of the CrPC. Your lordship may kindly peruse page number 50, 51. The deposition of the
where is the FIR?
FIR is at page number 11, my lord. The complaint of the FIR is at page number 15.
This is 147, 148, 506.
And 3 of the SCG. Your lordship may kindly peruse the statement of the complainant, what he stated, my lord. Page number 50. May I read you?
50.
Yes, my lord.
Yes.
May I read, my lord? Yes. I am the informant. I have lodged this report, Exhibit 1, with the police. Exhibit 1 is my signature. I know all the accused persons who are supporters of BJD political party. I and most of the witnesses are locality belongs to Congress party. I was chairman of Lamtapur block. Prior to 2007 chairman election, there was election of Jilla Parishad and Panchayat Samiti in February 2007. That is on 17 February 2007. On 16 February, all the important Congress party supporter, including me, made a pre-election feast village at Bonamaliput in the house of Kishore Naik. There was only enjoyment in the feast without any trouble or disturbance. After the feast, when we were returning to our respective villages from village Bonamaliput, the police apprehended us at Nandapur and took us to Nandapur PS. Then I lodged this FIR. The accused party were also in Nandapur PS and they had reported against us to the police. Police arrested both parties and forwarded to court. We have compromised all our dispute with the accused person. I am a member of scheduled tribe. My case certificate was seized by police from me under seizure list.
You will get the bail because the informant herself says that I have compromised.
But my lord, what this honorable court passed, what the learned court below passed this order, your lordship may kind. That is under 232. Pass the order of acquittal, my lord, without examining the IO and without examining any other witness. Only 3 witnesses are examined in 2 stages of trial.
Who are you?
I am one of the accused.
You are acquitted.
Not 9 accused persons are acquitted, your lordship, except me.
You are absconding.
Absconding.
But then you get the bail. What is the problem?
Bail though.
Re-SST sessions tribal case.
Tribal of, my lord, here.
Don't say master having no power.
I'll make same day.
Yes.
Same day, you would, same day. In view of this, you would be granted.
Your lordship, two.
And for the other accused person, the informant says that I have certificate issued. On that basis, there is an acquittal.
Your lordship may kindly issue notice to the complainant in this matter. If he appeared, then they will compromise the matter here.
Yes, Mr. Maharaja.
My lord.
He says that don't pass any order, issue notice to the, yeah. If he comes and he makes the same statement, it can be disposed of here.
Right?
We'll
Yes.
pause the entire proceeding.
Yes, yes, yes.
Because he has already deposed before the court. That
all evidence किसी नहीं.
But an issue notice to the opposite party number 2. Have you implemented?
Yes, your lordship.
Opposite party number 2. Written evidence, sir. How many accused were there?
Accused, 10 accused person are there, my lord. 9 are already acquitted.
Now let call for the petition submits that there were 10 accused. There were 10 accused in the 10 accused in the FIR report, including the petition. 9 accused persons faced the trial and they have been acquitted. During the trial, the complainant herself had deposed before the court that he has settled the dispute with the accused persons. Since there was no evidence against the accused persons, all the 9 accused persons have been acquitted by the wide order dated.
Well, order dated, your lordship.
Where is that?
My lord, 22/12/2009.
22/12/2009. The petitioner has been absconded. Therefore, the court below has issued NVW against him by order dated 6/12/2007. 6/12/2007. Issue notice to opposite party number 2 so and so till further till next date of hearing. The execution of NVW dated 6/12/2007 issued by the SDJM in GR case number 109 of 2007.
Gratefully.
32. Take the notice and serve.
Yes,
let him come and put the post. Yes.
Grateful.
32.
Order dated 15/3/2022 and the court below has taken cognizance of 498, 494, 323, 354.
Please speak in the mic.
344.
Yes, yes. What are the
307 and 506, 34 IPC and 4 DP Act, madam. They initially a case under registered in a case under section
498 and all.
Yes, madam.
Who are you?
I am the husband, madam.
Husband?
Yes, madam.
Have you settled the dispute?
No, my lord. What happened, my lord, in this case? They without on the basis of the medical report, my lord, has submitted charge sheet on the 307, my lord. At best, it can consider 323 IPC, my lord. Can you see the medical report that is under annexure number 4, page 36, my lord.
Yes. You beaten your wife?
Yes, my lord.
Very good.
That is the allegation. Page 36, my lord. No recent external injury seen, my lord. One black mole and another is one black mole. On the basis of that report, submitted charge sheet, my lord. Initially,
You beaten your wife and in-laws, everybody.
that is the allegation, my lord. Prior to that, my lord, the informant,
Is it simple in nature or what?
no recent external injury seen.
I'll just issue notice, let us. Later come. Issue notice. Why don't you settle? If this is the stage in your house, you go to your in-laws house and beat your wife and in-laws and everybody.
No.
It's better that
That allegation is false allegation, my lord.
settle the issue.
Yes, ma'am.
Yes.
I is there.
Let us consider. What is the stage of investigation?
Previous will continue, my lord.
No. You were on bail, huh?
Yes, ma'am.
Charge sheet file.
Charge sheet file, I was on bail.
What is the threat then?
Pardon, ma'am?
What is the threat?
Stay up further proceeding, ma'am. Stay up further proceeding. I.
First trial चलता है stay मागुଛନ୍ତି. If it is settled, then question of
Are you interested to settle and record it?
No, I am interested, but
This dispute is primarily arising out of a
Matrimonial.
matrimonial court, and petitioner is ready and willing to settle the dispute with his wife
Yes.
and seek indulgence of this court. Issue notice to opposite party
Yes.
number so and so. And in the meantime, the proceeding before so and so is stayed. Settle the issue.
33.
There is no point aggravating it further. Yes.
The present petitioner is the mother-in-law, my lord, the 80 years lady, my lord, the, let's say, anniversary of the, she was on bail, my lord. Subsequently, after charge sheet, she has issued notice for appearance, my lord.
80 years.
Mother-in-law.
Mother-in-law.
Yeah, last occasion, my lord, she had the matter, my lord. Due to her illness, she could
But
not
why have you not implemented informant? These are minimum things, sir. In the matrimonial dispute, you must
that Lordship help for a moment. The matter is in list, my lord. The Lordship suggested, my lord, to file a petition for quashing, my lord. I have filed an application.
That's right, but you
that is item.
Did I tell you that don't implement the necessary party?
That item is 53. Lordship allow me include the party. That
Why are you taking this liberty? And after July, that liberty will also be not given to you because everything will be online. Everything will be online. You can't ask for the hard copy and write something. Develop that. These are minimum things.
I think without notice, your Lordship will disturb the matter. For that reason, I have not included. 53 days, I will file.
Which matter?
Item 53.
53. 53 or 8 at the time. Then cause for the petitioner seeks leave of this court to implead the informant as the opposite party number 2. He may do so during the course of day. Issue notice to opposite party.
Notice
Okay. Mr. Maharaj, she is 80-year-old lady.
Yes.
Matrimonial dispute, I'll say.
Stake up.
This lady, yeah?
The petitioner, yes.
In view of the fact that the petitioner is 80-year-old lady and he is the mother-in-law of opposite party number 2. Opposite party number 2, the further proceeding, the present petitioner is stayed. Implead immediately.
Just now.
যদি হয়ে গেল কিছু ভালো কথা হলো যে so far the impugned order is concerned the procedure is to be
80-year-old
সেটা
unnecessary.
For that reason, Lordship would suggest.
Yes.
Both 53 also, huh? 53 and
সেটা
issue notice करके stay करते हैं. Yes.
34.
34, let's say the first date of appearance notice NBW was issued against the petitioner, so let's say. And
bail data को
mail के पास ले अपन.
the petitioner, let's say kindly come to the page 6, my lord.
23/6/2015 bail 18/4/2023
24/3/2018 24/3/2018
fresh NBW ଟା ନିଅ କାଇଁ ସେଟା କାଇଁ ପୁରୁଣା କାଇଁ ଦବ
ହଁ 18/4/23 ଦି ଜଣ કરે two petitioners are there, my lord. First petitioner number 1 is Lordship, NBW was issued on dated 24/3/2018 and on dated 18/4/2023 petitioner number 2.
Into petitioner number 1 is concerned.
24/3/18
24/3/18 NBW and petitioner number 2 which is
18/4/23.
There are 2 orders. There should have been 2 petitions anyway. And stay कर दियो.
अधिक अधिक पैसा है
500, huh? 500.
Yes.
500 each.
Oh, bless you.
Because 2 petitions you are supposed to.
So bless.
NBW 30.
35.
Yes. 35. At the request of the non-APS for the petitioner in the interest of justice and judge. Yes.
36.
36 may please, Your Honor. Here in this case, my lord, the petitioner challenged the order dated 29/2/2029, my lord, page 21, my lord.
Yes.
The police petitioner is a police officer, my lord. While he was raiding the house of the complainant, my lord, it is alleged that she has broken the door and entered forcefully in the night, my lord, for which a complaint case has been registered against the petitioner. and a notice was issued. Subsequently, my lord, your lordships may
What
kindly.
is challenging?
Here, my lord, on the same day, your lordships, for a moment, your lordships may kindly see page 21.
20?
21, my lord.
Okay.
Peruse the case record. It is found that the alleged offence are triable by summons procedure, but by the offence is under section 506, your lordships may kindly see.
Where are you reading?
My lord.
Page 21.
21,
Which
my lord.
proceeding?
On the same day, my lord, you are surrender. On the same day, my
Where
lord.
are you reading? Let me understand.
21, my lord, page.
21, na?
My lord.
Peruse the case record.
My lord.
It is found that the alleged offences are triable by summons procedure. Hence, in view of the honorable motivation, so what do you want?
My lord, my humble submission, lord, 506 is not the summons procedure, my lord. That is warrant
The
procedure.
High Court notification. Where is that notification?
That notification that is not with me, my lord. But your lordships may kindly.
Now, in view of that notification, that order is passed.
My lord.
Notification answer order finds.
Wait, you get that notification?
Notification on a High Court website.
In public domain. You get that notification. You have
Apart from
entire
that,
case is on that notification.
apart from that, your lordships may kindly see on the day on 29/5. Cognizance, the bail has been granted, my lord. On the same day, charge has been framed and same day trial fixed for trial. I am unable to file, my lord, because 197 is there. I am unable to file any petition.
Where is that? Where is that?
Your lordships, previous date, your lordships, previous order, your lordships may kindly see.
Where is that? In view of the order.
Page 19. Sorry, page 20, my lord.
20 years.
The case record is posted today for appearance of accused, namely Purnachandra Patayat present, so and so, my lord. He shall appear and when bail was granted, my lord. Later, your lordships may kindly see.
Third, where is the record?
Bail was granted.
Police officers currently posted on administration. We stay detention. Where is the charge frame? Nothing.
My lord, charge because on the same day, your lordship may kindly see accused is absent. Next order, lordship may kindly. Accused is absent.
Where?
Issue summons, your lordships 21, your lordships page 21 on the order which I have placed before lordships in the same order, my lord. For trial, issue summons to the charge sheeted witnesses. The prayer is allowed, issue summons to the charge sheeted witness, fixing at the for evidence.
Where are you reading? I am not able to.
21, my lord. The order I have challenged before lordships. There is the order, my lord.
Where? This part is not there. Where are you reading?
There is the case record.
Notification. After the notification.
After the notification, my lord.
Yes. 21.
Yes,
my lord.
Page 21. Your lordship got it that notification.
Number so and so.
High Court notification. Just below.
Particulars of the
Offense so and so is read over and explained to the
accused.
Just below.
To which he is not guilty of the claim and trial. If it summons to. Yes. Yes.
गोटे दिन रे सब भल कथा ना शीघ्र हो
police officer टा चार्ज
first you file the notification.
Notification answer
get that notification.
My lord, sir, trial ta hijo.
Good दिन within 2 days trial भी खत्म ही हो.
Tomorrow, my lord.
Get that notification. That is your whole case. You don't file that notification.
Notification, my lord, may be difficult for me, my lord.
Shall I get for you?
No, I'm not verify because
your entire case is depending upon a particular notification. That notification you have not filed.
That order.
That's the only ground you have.
My lord, that on the appearance date, my lord, everything has been done, my lord, and is arising out of a complaint case, my lord.
Issue notice. Or to opposite party number 2 written so and so. In the meantime, petitioners and counsel submit that he would move application before the court below, seeking adjournment owing to the fact that the matter is submitted. Yes, next.
37. My lord, pray for if you file an adjournment petition, at least your
that I have said already. You have not listened.
Oh, blessed.
Yes.
37.
Please, your lordship.
Yes.
this case was before Lordship on 14/5, adjourned today for appearance of both the parties. Informant is seriously ill, she could not come, my lord. My lord.
After vacation.
Your Lordship may kindly no coercive action, my lord.
No, no,
because,
that I will not.
Because
You have taken many time to
no,
bring.
my lord, only one time. First
Whatever
time.
you, I gave the date particularly today because
Yes.
you said that I will bring the parties.
She's ill, my lord.
So this maybe
People Lordship,
you should have moved application or something. I said to you.
my lord, through VC, I can also.
He should have appeared. Today also he can appear. See, the court can't wait for the accused persons, and you have been seeking indulgence of the court every time you say that I'll bring the party. You don't bring and coming and asking for.
Tomorrow, my lord, tomorrow. I pray
No
tomorrow.
question of tomorrow. We can't wait for the accused like this. In the religion. Yes,
no coercive action only.
No question, sir. Don't take the court so lightly. So heavy day, these last 2 days, I kept it only because of the parties will come, I'll dispose it up. Yes. And now you're coming and saying that no, they are not coming.
Or during vacation.
Under their mercy.
During vacation, your Lordship may grant liberty to move.
Mention before vacation. I can't control the vacation code. Yes.
This is a very unique case of its character, my lord. I mean, this arises out of the 138 proceeding.
Perhaps you made it very unique.
No, it is a unique case. If your lordship, yes, it will be a unique case.
Yes.
I am sure your lordship might not have come across such a.
You are one of the accused.
I am arraigned as an accused. What has happened, my lord? This petitioner, he had purchased a crop cutting machine on financial assistance of the private finance company, that is the opposite party here. My lord, there was a default. Admittedly, there was a default. So the security checks which were given to them, my lord, they utilized one of the security check, my lord, and they issued a demand notice to me. I also replied. Thereafter, nothing, my lord, there was no communication whether there was any instruction of any 138 case, my lord. Thereafter, they initiated arbitration proceeding at Calcutta. The arbitration proceeding, award was passed for the whole of the liability, including 16 lakhs odd with interest at the rate of 3% per month. Now, what they did, my lord, they utilized another security check, my lord, calculating the whole amount as, my lord, as per the arbitral award, including the interest.
Execution.
They initiated, they utilized another.
Have you filed 34? Have you filed 34 objection?
No, 34.
Then you are accepting the award.
Yes, there is no difficulty in that. Whatever is the amount, they have utilized another check, they have instituted another 138 case for the whole of the legal life.
Including that arbitral award amount.
Arbitral award amount with interest.
You had given 2 checks. You had given 2 checks.
I had given 4 checks. First, they utilized 1 check for 6 lakhs, my lord, part of the liability. That they issued a demand notice. Thereafter, I do not know what happened. Thereafter, they initiated an arbitration proceeding. Arbitration proceeding, the whole of the amount along with interest and further interest at the rate of 3% per month was awarded by the arbitrator. Now, that whole of the liability along with interest, they presented another check, utilized another check and presented it.
Right. The petitioner is the accused in 1cc case number
1cc case number
5630 of 2021. 2021. Mr. P.K. Mishra and counsel for the petitioner submits that the petitioner had a business transaction with opposite party number 2, for which 4 checks.
Number 1.
Opposite number 1. For which 4 checks were issued as a security. Initially, 1 check was used by the opposite party. 1 check of rupees 6 lakhs was used by
6 lakhs 24,000 500.
500 rupees initially was used by the opposite party. Present initially. Was presented by the opposite party for encasement. Presented by the opposite party to their banker, since the same was same was legal notice was issued to petition. The notice was appropriately replied. However, whether complaint case is filed or not is not known to the petitioner. When the matter stood thus, the opposite party referred the matter to arbitration. After arbitration, where is that arbitration?
Nowadays, the connection.
By 21/12/2022, the arbitrator.
3/10/2020. 3/10/2020.
The arbitrator by it's about dated 3/10/2022. Passed an award against the petitioner. Instead of executing the same award, the opposite party have utilized the subsequent security checks which were lying with them and lying with them. Lying with them and filed the present.
Calcutta file करछन्ते आउ गोटे case including the whole of the liability. There the notice was issued. I appeared and I am contesting.
What about this now? This is another check.
That was another case.
What about this case?
This case, my lord, a part of the liability previously it was filed in the year 2020.
Complete case before Calcutta.
Calcutta Metropolitan Magistrate at Calcutta. Chief Metropolitan Magistrate at Calcutta.
CMM Calcutta. Okay. In so far as the present case is concerned, the third check is used.
The previous check is the yield place करथिले सेटर से इंस्टीट्यूट कर देले मु जानि नि सेटा इंस्टीट्यूट एबे तादर नोटिस पाए दे पहुंचे so so far as the present case is concerned
the petitioner has now received the summons in the ICC case appears to be initiated by the opposite party in regard to the check initially in regard to the dishonor of the check for which the notice was issued. In view thereof, issue notice to next problem. In view thereof, issue notice to opposite party number 1, written so in the meantime, the proceeding before below in ICC case number
166 case number 5630/2021.
Why it is 20 pending before the SDM Bhubaneswar state. Yes.
39.
Okay.
39 my lord. Annexure 1, page 8 my lord. Kindly peruse my lord. Since the petitioner is a habitual offender, therefore the subdivisional magistrate Jampua directed him to appear on
same government employee.
No, it's a premature case. Let him approach.
No. What he says that surety, local surety.
My lord.
This is only a notice under section 110. No order has been passed under 111.
No, but he has to go and furnish the bond.
Your lordship.
Bond, no problem. But where from he'll get government employee?
My lord.
He
1805 my lord.
Ask whether he has to submit a bond or not. For that, an order under section 111 has to be passed.
No,
that
he will
order
go.
has not been passed yet.
Why
is
not
only a notice. Notice to show cause as to why you will not be required to execute.
Thereafter, under 111.
That then I passed the order that he will go and.
CRLMC
I
1805.
passed that order. I say that I recorded the submission and I have sent it. Right.
Who called the CJ Super Saver?
Then the counsel for the petitioner submits that. नहीं इधर लिख दो seek to withdraw की first paragraph लिख दो हाँ withdraw first paragraph लिख दो तापर counsel submit that none of the family members ये second paragraph लिख दो हाँ same and go move application. I have recorded your statement. And you show cause stage, you only go and tell that I can't furnish government.
CRLMC 1805.
Yes, we allowed. Yes.
40 joules same another bit.
Allowed. 40B.
40. Same.
13 and 40B then. Same order of allowed.
41.
Made vision, my lord.
Yes, sir.
41 is a case. Sir, the petitioner was involved in a two case out of same issue, and one case was registered, that is Clercy page annexure 1 page 14 and another is annexure 2 page 18.
Involved in two cases.
My lord?
Involved in two cases.
Involved in case was registered two case, but incidence is one. Which one FIR is registered under section 341, 323, 307, 506, 34.
Cognizance is taken in which case?
Both cases.
In which case is according to you correct?
My lord, one incidence. There is no another case.
It's all right, but which case shall continue and which case?
My lord, 307 is not made out against me. There is absolutely no basis on which the 302 is made out. And subsequent FIR, the Clercy
307,
323, 34, 341, 506. And another is 341, 323, 506. All same.
Occurrence is?
Group ro jo thila dita FIR le korle self control pai ho. Which is bar according to as per the provisions of law. This is Clercy say 223, 222 read with 223.
The same day, for the same incident, two FIRs have been filed by the opposing parties. Cross FIRs.
But occurrence is same. One occurrence. How the two FIRs is registered?
Occurrence date is 22/10/2023 at 11:30. First FIR.
Yes.
Second FIR, same 22/10/2023 at the same time.
13-15 hours.
No, 11:30. Both are 11:30. Just see page 18.
18. Yes.
Page 18.
Page 18, wala date and time of FIR is 5:41.
No, page 18, column 3.
Yes. Same
Occurrence date.
Yes.
See date from 22/10/2023.
Yes. Same incident here.
Time is
same incident.
Then
but cross FIRs. Well, therefore, question is whose version is true?
You will have to find out.
Your lordship may issue notice to the private doctor.
You will have to find out.
And I'll call for the.
Let them take instruction. Let's me. I is there. Let's me play interim protection.
So this is the only what stage?
My step
cognizance.
Further proceeding is state. This is the only.
You move application.
Already filed an application.
No, you are just. Party that you move application to the court below seeking adjournment case owing to the fact that the matter should be reached before the court. Issue notice.
43 also same. 43 also same.
43, 41, 42, 43.
No, my lord. 41 and 43. 42 that I am just going to move, my lord.
Issue notice. Notice and he will move application for adjournment.
Obligement.
43. 42 मुझे रहेगा
42 टा मैंने सप्लाई मेंशन करती है बेटा CNTR नंबर सहित तीन काल कुछ କରିବାକୁ ଦେଇଛି
नहीं अच्छा that's right କରିବା ତ କରିଦो ଯଦି କରିବେ my lord will fix at 3 o'clock that lordship may remember that boy 110 meter he was apprehended by the
last occasion my senior my lord
while moving the application stated before the court, there is no such antecedent against the petitioner, my lord. When, my lord, I have often
My lord, let me clarify. Let me clarify.
7 cases, my lord.
ठीक
For
है.
believing him, my lord, you lordship directed him to move before the court below, my lord. And he moved before the court below, my lord. And somehow
That was rejected.
No.
That was rejected on the ground.
No.
Mentioning there in that 2 cases are pending.
No,
Mentioning there. What is that case? Now I am considering 3 cases. All are, one is police, 2 cases are by police. Again, mu patka kadi deythili, slogan doutili 50-60 jana gar thili.
Serious allegations.
All the allegations are, we are in public move. We are in agitating mode.
There, my lord, can't say.
It is unfortunate a officer,
This person
in spite of direction of the Honorable Court, even though he is a senior officials of the state getting the IS, he can't defer the High Court.
No.
Whoever officer may be. Even once the application has been filed, he don't dare to do so. Go through that, you move the application. We have filed the application for the SDM. SDM showing on that day that I am busy, I will pass the letter and order because the election, in fact, nomination is going on. So we have thought that the senior officer, his election process might have passed by evening. That day has gone. Next day, when the lawyers are moved.
But now, what is the stage?
Stage is, as it is, I am in jail. And they are coming with a 7 cases are against me. Now I got papers because no record is passed on to me.
Let us understand.
Yes.
In all the 7 cases, whether he is on bail. 1 minute.
No. Some cases, my lord, some cases, my lord, against
Have you taken him into custody in any of these 7 cases?
No.
1 minute.
What happened in this case, my lord? When the someone issued from the court, my lord, the police personnel went to his house to serve the summon, my lord. He, my lord, did not receive the summon and abused the police personnel, my lord. Thereafter, another summon, 3rd time summon issued, my lord. Then only, my lord, he went to the, did not, my lord, respond, my lord. He warrant issued.
Only you answer me one thing. Whether you have taken him pursuant to 110 notice.
My lord.
If you have taken him under 110, how can you retain him in the custody? How can you retain him?
He not obey the condition.
What are the conditions?
1 lakh
Bail
rupees,
bond.
1 lakh rupees and 2 solvent surety. My lord, even if not file so good, my lord.
Not
In the
solvent
court, my lord,
surety.
he asked
Two
to the,
officer
my lord,
in class 2
AG,
rank.
I will not give him the surety, my lord. For that is taken to custody.
You have not given the bond.
How can I give it? There are 2 class 2 officer Hoyler get. They are given the 1 lakh.
Those orders I am modifying, all the orders.
Lordship may modify and ask and we will punish the bond. If my lord will modify, that day I also requested my lord to modify the same.
You can't detain someone under the guise of 110.
Why, my lord? The Supreme Court, Honorable Appeals Court in a decision, my lord, 1 case, my lord, he has violated the condition, my lord. And the
That stage has not come, sir. Only thing is, he is supposed to furnish the bond. You say that 1 lakh plus 2 surety of like amount, the government surety. And in all the matters where these kind of orders are passed, I said that what is the government surety? They are the criminals. Where from the which government servant will stand surety for them?
Get to class 2 officer. Reasonable as we will consider.
You tell me a person having 7 cases, any government officer will stand surety for them?
From the conduct, he does not deserve it.
Impossible.
They have not, they have challenged the only summons, my lord. They have not challenged any order, my lord. Conceal also any order challenge, my lord. That case is not maintainable here, my lord. Since his case, they have conceded the prayer.
Everything will decide on merit.
No,
I am on limited one.
My submission, my lord, their petition not maintainable at all, my lord. That is my whole submission, my lord. Then I go to other, my lord. Whether that has been modified or not, that is a separate thing, my lord. But in fact, they are, my lord, the prayer is not sustainable in the eye of my lord. They are, my lord, coming here, challenging notice, my lord. Notice is already over, my lord. They are taken to custody. They refuse.
That is what I am asking. How can you take someone into custody under the guise of 110?
3 years he will remain behind, but so long he is not.
You see the conduct of
preventive detention.
My lord.
Preventive detention.
Yes, my lord. It is a preventive one, my lord. Preventive, my lord. My lord. Law is that, my lord. When a person did not honor the summons, my lord, then a warrant issued. He has taken to the court, my lord. In the court, open court,
you furnish the bond immediately today.
My
I'll
lord.
take it. Go and furnish the bond today.
My lord, I am ready out, my lord.
Let him furnish the bond today. And the guys of 110, you can't keep someone. You take him into custody in any of the case you want.
Well, it's one submission. Your Lordship may look at his conduct. In the order dated 10th of April 24.
One minute. My lord, can see this order, my lord. I am giving the order, my lord. Can see. What is his conduct, my lord? How, my lord, he has also damaged the vehicle of the SP police, my lord.
Conduct will be vice versa.
He's creating a
You see a person, boy is fighting for society.
You registered a case, everything, but 110 you can't use.
My lord, 110
Registered a case, hang him. No problem.
He will, my lord, so long he is not punished, my lord, he will remain, my lord, there. And their prayer not then modify the order, my lord. The statewide challenge is summons, my lord. Their prayer is not clear, my lord. Can't see their prayer.
Why are you saying that I will not give surety?
No, it is completely wrong. It is wrong submission. My lord, there is written of them.
Yes, the delinquent has rejected the option of providing surety and executive bond as directed by the court. If that is the case, then you will be.
My lord, it is a completely wrong submission. What I am saying, Susu, they on 30th he was present. He asked this SDM that I am punished. I don't know what for your honor is apprehending me. 1 lakh is impossible and 2 government security is unimpossible. So you give me some liberty.
Have you moved any application?
Yes,
for
we
modification?
have modified the application is moved. The order was passed. What I am now hand over to my lord.
Where is that?
They have modified to the extent 25,000 and that 2 government security. This is the order.
That is not a modification. That is pursuant to your Lordship's
Your
order
order,
to
my lord.
approach for bail.
And they have to give their agreement.
Considering your lordship's order. Considering your lordship's order.
For it to my lord.
There is a political vendetta. All right, you are capturing the boy. It's fine.
2 government sureties, class 2 and
1 lakh rupees.
Looking into the character of this man, no government employee will
No,
stand in this.
my lord, that is behind, many things are there, my lord, behind the crime, my lord. He is creating a havoc in the locality, my lord. And
registered a case and take him into custody.
There are cases, my lord. He must be.
You can take him into
He has
custody,
been-
but don't employ 110
My lord,
for that purpose.
in 110, my lord, they have to file separate for lifting the condition, my lord. Not for it, my lord. Can you see their prayer, my lord?
You seek cancellation of bail in all the 7 cases and
But
take
that
him to
is
custody.
so far my submission before, my lord, can you see their prayer, my lord? What is their prayer, my lord? Their prayer not existing, my lord. How come that your lordship quash the, my lord, the
What I'll do is, so far as the government surety is concerned, I'll waive that condition. You go do whatever. And you, it seems to be very adamant.
No, my lord. I am surrendering. I am filing application. His parents are appear before the ADM.
Okay.
They have said that we are ready to submit the bond for our son.
I'll list it before vacation bench. By the time you furnish the bail bond and get out of
Limited prayer, my lord. Lordship may pass a judicial order here. Because their SDM is not able to listen anything. Such a situation they are.
I sincere request to your lordship. No, don't pass it.
I don't know how the government council is so eager to issue. A boy have a 25 years age and he has involved his lordship. Hear the matter.
That's all. I'm not saying anything in so far as this petition.
We are ready and willing to punish the bond.
Yes. Pursuant to the order of this court dated 13/5/2024. Mr. P.K. Patil, let counsel for the petition submits that pursuant to the order dated 13/5/2024, his client moved an application seeking variation of the order, variation of the impugn, variation of the which order, summoning which order is that?
This order is
notice, variation of the condition. Where is that order? Where is that notice? Variation of
that is annex page. Annex 2 page 21.
21. Variation of the condition enumerated in notice dated 24/4/2024. Whereby he was asked to appear on 30th April 2024 and furnish bail bond of 1 lakh rupees with 2 government sureties of class 2 rank officer for like
class 2 rank and above,
for like amount for good behavior for a period of 1 year into local. He moved the application before the court for variation of the said condition on the ground that none of his family members are government employees, so therefore he can't secure the surety, government surety. The court below has court below by the order dated 14/5/2024 has already although modified the condition but directed the petitioner to furnish two government surety of class 2 rank class 2 rank of
And above.
25,000 of 25,000 each. 25,000 each. Mr. Padi, Learned Counsel submits that since his case throughout, there is no government servant available to government servant available for maturity on his behalf. Therefore, he seeks, modification of the schedule. In view thereof, Mr. Padi submit that he would move press application before the competent authority for variation of the same order and leave the matter on service.
My lord, I will let me clarify one thing. This instead of government surety, suppose another rec.
I said that you have no government surety is available. You move application. I am not saying anything.
Disposal. Disposal.
Huh? No. It's a lie over.
Let it be there.
Lie over. It is a lie over, man.
If it's not there,
No, you have to file a fresh petition.
No, I will file my lord, but application by lie over.
Mr. Raghuda submits that in the present case, the petitioner have only challenged the
summons, the summons is 6/4/2024.
My lord, specific pair is there.
Summon dated 6/4/2024 and 24/4/2024 issued by the sub-regional magistrate Bailable. In view of the order passed by this court on 13/5/2024 and the order passed today, the petition is no further order is required in the present petition. Hence, the present petition is disposed of with the liberty to the petitioner to liberty to the petitioner to approach this court if any cause of action still some.
One line may be added, my lord. Further prayer, their prayer, please to quash order illegal detention 110 of the
No, that I am not doing.
They have not filed any document to show that they are.
I am not declaring that it is illegal, whatever. He will move application. You immediately today.
Yes.
Move application.
Yes, obliged.
Will come out at least.
Morning court, tomorrow will obliged. Urgent circuit.
Filed one petition under section 205 of CrPC. And because he is suffering from kidney dialysis, kidney problem is there. I have annexed the medical certificate at annexure 4, phase 4, and that 205 application has been rejected. She was never arrested during the investigation, and someone was issued to him, to her.
What is the offense?
Offense is 13(1)(c)(d), reduced section 13.
Yes, Mr. Mara.
Some in person not arrested. In view of that, Mehdud Baba's case, she has to give release on bail, an appearance and executing bail bond. If 205 is over, 205 is concerned in terms of that on it Puneet Dalmia case.
Well, allow it. And move press application in the light of.
First, she has to appear and execute on bail bond.
Once you have to go, that's what it is.
Yes, she has to go appear.
Once she will go, my lord, but
Well, she is in dialysis.
Otherwise also.
Give the citation.
CBI.
No, সেটা 205 ପାଇଁ মেহদুদ বাবু কହୁଛି bail ପାଇଁ।
Both the judgment you give it. petitioner is agreed by the order dated 2/3/2024, passed by the special judge Vigilance Katak in TR case number 12 of 2023, whereby his application under section 205 CrPC has been rejected. And consequently, the petitioner submits that the petitioner is a lady. Petitioner is a lady of petitioner is 56-year lady, and is suffering from kidney
Nephrotic
problem. As a result of which she is undergoing dialysis, regular dialysis. Irregular dialysis. Therefore, application under section 205 CrPC ought to have been allowed by the court below. Mr. Marana, then cause of the vigilance states that in view of
the she has to appear in view of the Medud Baba versus CBI 2023 live law Supreme Court 218 para 10 and 12. She has to appear.
The petitioner they move press application before the court below.
For bail.
Court below. Court below. Court below. Court below. In view of the aforementioned circumstances, I'm inclined to decide the order dated, impugn order dated so and so, and grant legal to the petitioner to move a request application before the court below. If that application is made, the same can be considered in the light of the judgment.
In terms of the Punit Dalmia.
Punit Dalmia, Supra. Yes. Yes.
45.
Sir, what the case is it a quashing fine? Quashing of cognate that will go. No, assist and that will go.
No, I am passing this. Yes. Yes.
In the file of the London JMFC ground here, in GFS number 75A of 2004.
Ground?
That is the split of case, which are been constituted in the file of the London JMFC from out of the original case, which has been disposed of by judgment under Annexure 3 series. We are kindly happy glance of Annexure 3 series that page 31.
They are acquitted.
All the accused persons are acquitted. Because these two petitioners were staying outside and were giving intention that the proceeding is not going to proceed further in the matter. You may not be required to appear. So that's why they don't appear, and the split of case has been constituted. All have been.
What are the ground of acquittal?
Your Lordship, may kindly turn to page 38. 38. The last.
Paragraph 6, last 10 lines.
Yes.
But the informant.
3 lines.
Yes. But the informant, who is the vital witness of the prosecution himself, deposed that he did not want to proceed in this case. Since the complainant himself is not desirous of prosecuting the accused person, no adverse inference can be drawn against the accused person. Moreover, if there is not a substantive piece of evidence, without any corroboration from the informant with the affair, it is not possible to stand the prosecution.
Yes, you have you included the informant? You should have implemented. You should notice. I'll pass it here. Bring him.
I was in the several cases. Several cases of when it will be a grant the accused person to criminal court. And
all the offences, I think all the offences are triable by magistrate. And the informant is no more interested to proceed. Even the victim, P2,
it has not. Right on.
That is the evidence.
Petitioner is one of the accused in FIR number so and so. Along with the petitioners, there are 2 petitioners. Petitioners are accused in FIR number so and so. Along with how many other?
11.
How many?
There are altogether 11 accused persons.
Along with the 9 other accused.
8 have been acquitted. 1 was abetted being dead.
Along with 9 other. Except the present petitioners, 9 accused faced the trial. During the trial, accused number who died. Accused number so and so died, as a result of which the trial was the said accused.
Brahmananda Lenka.
Brahmananda Lenka. Was the said derivative. Insofar as the other 8 accused persons are concerned, they were acquitted by the court of JMFC by the judgment dated 18/7/2023
Your Lordship may kindly correct it. Ratnakar Lenka died.
In the trial in the GR case number 75 of 2004. While recording the acquittal in favor of the said accused person, the trial court concluded that neither the informant nor the who are
PW2
PW
victim Puspalata.
PW2 Puspalata
Yes.
did not support the prosecution. And insofar as the informant is concerned, he also appears to be not desirous to prosecute the petitioner. Therefore, the court below has recorded an acquittal in favor of 8 accused persons. 8 accused persons. Next one. Relevant would be to reproduce the judgment of the court. Judgment of the court below, whereby the 8 accused persons have been acquitted. Para page 37. Para it will start in this case FIR. In this case FIR will start last day. It's not possible to stand in the prosecution. Yes. The petitioners have been absconded. Why you were absconding?
One was on bail. Another was
Absconding. One of the petitioners was on bail.
Petitioner 1 or 2.
because there was petitioner was one was on bail.
Although the petitioner number 1 was on bail, petitioner number 2 was absconding.
Yes.
Absconding. Absconding. After the judgment passed by the JMFC Gondia, Bengana, the present petitioners have approached this court seeking quashing up the entire criminal prosecution against him. Perusal of the judgment of the JMFC, JMCP Gondia, dated 18/7/2023 indicates that there is absolutely no evidence adduced by the prosecution to support the case. Sorry? Who are you?
I am the Hon'Ble. The victim was died on 20 lakhs. The other was not on 31/8/2018 lakhs. In the meantime,
As here the informed the wife passed away from cancer, not related to the crime itself. So therefore, but there are several other 161 statements which say that
498A and everything is there.
Yes, Maharaj. So let him.
Where is the question 307?
No, there is no 307. Maharaj.
So FIR is 307.
The charge sheet.
Charge sheet, very charge sheet. Cognizance is taken. Cognizance is also 307.
Oh, yes, yes.
What is this?
And several 161 statements say that Marpit Hosla, Pitapiti, Maramari Hosla.
That would be the 498 and all.
Yes.
Where is the question of 307? She died because of cancer. But all these things he has to argue in
Before
our stage.
your lordship may grant liberty to appear before charge. Acha, achi.
Continue.
Yes, sir. The wife says.
But cancer re morti pura.
The Purvuru is stated.
Death certificate is there. But you have to argue all these things before the trial court at the stage of charge. No.
Kindly supply lordship 46, the statement of which now lordship, the son of which
The petitioner is agreed by the order dated 17/2020. 1 minute, listen. 17/12/2020, whereby cognizance for offence under section 498A, public 307, 494 IPC has been taken against the petitioner. The legal counsel for the petitioner submits that even if the case at its face value is prosecution case at its face value is taken on account, no case under section 307 IPC or for that matter 494 IPC is made out. Therefore, he challenges the convenience order. I am not inclined to entertain this petition at this stage. However, as to whether a particular offence is made out or not from the charge sheet, the same shall be placed before the court below at the stage of framing of charges. In that view of the matter, liberty is granted to the petitioner to argue all the points before the court below at the stage of framing of charges. With this liberty, the petitioner is disposed of. Next. 47. Yes.
The complainant sound like very much mixed with the technical person, one of the accused. And due to COVID situation, married man cancer. And as a result of which, on the complaint of the ladies side, my lord, the Bhopal Sumat conducted a meeting and issued fine against the complainant. That is,
Yes.
that is for compensation of the family.
All these things are all right, but why cognizance order? Why should the court interfere in cognizance?
And he is in COVID duty, my lord. And he had not attended any meeting also.
So these are plea of LV. So then shall I?
So far as the initial statement of the police, my lord, nowhere the name of the petitioner is there.
All these things I can't go into at this stage, sir.
But now they in this public that otherwise
NWL has been issued.
page 26.
Page 20.
26.
Okay.
Cognizance order. If it is not appear, then
So where is that NWL?
no.
Then?
But the allegation so far as the against the petitioner are 420, 419, along with other party are also there, but the petitioner so far as
All these things I can't go into at this stage. That's what I'm asking. What to do? There is no courtship process issued against you. You are apprehending that the NBW may be issued. You so then go and appear and what can I do? Before the court below, appropriately have to try with this liberty, liberty I have given. Yes. Yes, next.
48.
My lords, I am appearing on behalf of the petitioner. Am I audible?
Yes, sir.
This case is with regard to an FIR. Kindly have a look at page 34.
32.
34. Page 34 is the FIR.
Yes.
And the contents could be seen the next page, just one paragraph at para 12. Just one paragraph.
Okay.
It says, the complainant Lakshmi Priya Mansingh, daughter of so and so, village so and so, Jankia Khurda, appeared at police station and presented a written report alleging therein that on 15th March 24 at about 11 a.m. when she went to college, at that time the accused Rasmi Ranjan Martha alias Rabi invited her to Ranpur court for court marriage, but took her to Kotagod Park, where his brother-in-law Sanu Palta Singh awaited with a four-wheeler vehicle, and both abused her in filthy language and threatened of dire consequence. When she raised objection that both the accused persons fled away from the spot. She further alleged that the accused Rasmi Ranjan Martha, Rabi, that's
What
all. Now the FIR has been registered. The sections are, what I am surprised is, sections are 493, 417, 294, 323, 506, 34.
No, whether charge has been filed.
Charge sheet has not been filed. No, it has not.
What do you want?
I am seeking passing primarily on the ground. Kindly have ground B for a moment. Ground B would be at page 6.
Page
6.
Page 6.
Yes. Now this section is like this. Every man, I read that?
Yes.
Every man, can I read more? Every man who by deceit causes any woman who is not lawfully married to him to believe that she is lawfully married to him and to cohabit or have sexual intercourse with him in that belief shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So this is actually introduced with a view to preventing concubinage. This is exactly not this. Suppose there is a relationship. Now I read.
No, it's all right. You say that 493 is not made out, or
Not at all.
376 is not made out. Okay, it's all right. Absolutely correct.
That's fine.
But
That's my
other offenses may be made out.
All others are bailable offences, and if it is examined, then you can see how the offences are made out from that paragraph.
No, this is at a very threshold. You know, the investigation is still on.
That's right.
Theoretically, you are correct, but what to do?
No, if I take all from Bhajanlal to Niharika, all these cases, when I'm seeing the FIR, no case is made out, then why should I be in trouble? I'm a government employee.
No case is made out insofar as 493 is concerned.
Even other sections, kindly have a look. Let's have a look.
417, 294, 323.
Yes, 417 is not an independent one. 294 is what obscene. Now let's see the affair. What is the obscene act?
Come to page 40. 40.
Page 40. Page 42.
The 161 statement.
161 is not appended here. In any case, 161 cannot be seen. Be that as it may, if 161 is there, then kindly have a look. Let's see. This is 40. Okay. All right. 161. All right. Let's see. Third sentence. I read it fully. Mo namo Lakshmi Priya Manasingh aji 15/3/24 tarikh madam ko nikotare deba mor bayano ehi ki je ମୁଁ ଜଙ୍କିଆ ଥାନା ଅନ୍ତର୍ଗତ ରାଧା ମୋହନପୁର ଗୋଡିକିଲୋ ଗ୍ରାମର ବାସିନ୍ଦା ଅଟୁ। ମୁଁ ଗୋଡିକିଲୋ ମୁଁ ବାଣୀକିଲୋ କଲେଜରେ ପ୍ଲସ୍
ପ୍ରାୟ 2 ଥର ସେ ମତେ ବିଶାଖାପାଟଣା ନେଇ ହୋଟେଲରେ ରଖି ମତେ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ।
My lord, kindly bear with me the third sentence. Kindly bear with me the third sentence. प्राय किछि दिन पूर्वे दिस इज द लैंग्वेज प्राय किछि दिन पूर्वे मो सानपदर ग्रामर रश्मि रंजन मार्था पिता बेणु मार्था सहित मोर परिचय हैला जे कि मो दूर संपर्क हेलो बोली नाबार्ड चाकरी करछन so meaning
as FIR charge sheet has not yet been filed. The 161 statement shows that this is a case of rape on the false promise of marriage. Therefore, the
No
section,
case is made out that way. That's what it
the
is.
sections may
No person till next day.
Till next date. And lease the matter on 20th of June. 20th of June.
CDR.
Because of vacation only this indulgence. Okay.
Then 50.
That's 498A, your lordship may issue notice.
I'll issue notice, huh? Issue notice. Issue notice. 498. Yes.
51.
Yes, you are on bail. Tell me date. Sorry? 5/11/22 and BW 22/1/2024. Okay? 500. Yes.
52.
If 498 case, your lordship may issue
I
notice.
issue notice 498. I just simply issue notice. Issue notice. Sorry? June 26. Issue notice returnable to June 26. Yes.
54.
Yes.
Where that railway accident case which happened in Ghana. Three of them were arrested and the proceed has been filed against 3 of them. And we filed a discharge petition.
Yes.
My lord, the petitioner is the grassroots level worker, my lord. He is a mere technician. What has happened, my lord? It is the station master.
The accident has taken place because technical failure.
No, what has happened, I am explaining. It is not technical failure, my lord. There are circuits, man. A diagram is fixed for every railway incoming trains and outgoing trains. That is the circuit, man. For which a diagram is done. And as per the diagram, my lord, the signaling takes place. And it is the role, the vital role plays the station master. This station master, my lord, when the incoming train used to come, they have to find there was a default, there was a fault, my lord, in those diagrams. Those there is a monkey, my lord, where the my lord is far away from the station, my lord. So there these people were working, and this person, my lord, this particular petitioner is on deputation, my lord. He was not a permanent employee over there. So when there was a fault, my lord, the fault has to be detected by the station masters. The moment it has to be detected, it has to be communicated to them. Then only they can take any precautionary measures. Now, my lord, in this very interestingly, my lord, station master, if I will straight away take away, my lord, to the accident.
This CBI is in there. I'll simply issue notice, let us see.
No, my lord, kindly appreciate one thing, my lord. Why I am asking about all these things, there has to be a complete stay on the proceeding. Because my lord, station master has not been implicated. And kindly see, my lord.
Without hearing the without hearing the CBI, I will not stay. In view of the serious nature of allegation, there are so many people died. There are so many people die. You might have been a. I will only examine one thing, that you might have been a scapegoat in the entire. That is what I will try to examine. But it doesn't mean that I will say the proceeding. Yes, Mr. Nayak has come. Yes, Mr. Nayak. Yes, I am issuing notice. Just examine it. We will see. I am not passing in any interim order.
After 6 weeks. One page that I want to show, madam. 166 page.
I am issuing notice. That's enough. I simply issue notice. Just examine. Only examine to the extent that whether this gentleman, who is a mechanic, has been made an scapegoat, and the right people were left out, and this man is, implicated.
So anybody might have been left out, but this person is a primary accused. Your lordship, I'll establish it on the next date of
You
it.
just see who are, what is the stage investigation? Charge sheet is filed.
Just because your lordship's accepting without admitting for the sake of arguments, just because somebody has been left out, that doesn't take away the culpability or
No,
criminality.
that's right. You are right. Absolutely right. Somebody is left out doesn't mean that he is not involved.
After 4 weeks, your
Anyway,
lordship.
anyway, you just check it up, huh? Okay. Issue notice, returnable. Yes, next.
55.
Immediately after the consent. Immediately. Yes. Yes, sir.
Lordship, after 20th, your lordship.
Here it is. 14th. Yes.
Informant is also there.
My lords, I am appearing.
Well, the Explosives Act is involved. Therefore, compoundable may not be permissible in this case.
It's not compound, quasi.
Because they've thrown bombs. This is not a fit case for compromise.
What is the injury? Where is the injury report?
Injury report.
Simple injuries.
Show me the injury report. You file the injury report.
Here, these are two persons who are not involved in the entire situation.
No, that is on merit. If you want it is to be quashed on the ground of this thing. And who all are the injured?
Informant is there.
No, injured.
He is the only one.
Injured informant same.
My lords.
What are the injuries? No, see, show me. It is a case of 307. Unless you know the injury, nature of injury.
These two persons, my lords, it's a mistake of fact that they've been implicated. There are five accused persons. 3 of them actually, my lords, threw bombs or whatever, my lords, there was an infighting amongst themselves. These two persons were not involved, they were unnecessarily.
Now
in the charge sheet, the petitioner is the main accused, the leader of the entire
And now there are 5 accused persons. Now the informant is compromising with these 2.
Yes.
What about the other? Partly can it be done?
But, my lords, who are the petitioners, the proceedings can be compromised. Subject to your lordship's.
No, then it will have an impact on that. You can't, being the victim and informant, you can't choose, I will settle with this man. I don't know whether under pressure or taking money. I don't know what are the considerations.
No.
How can it be done like that? It's a offense against the state.
No,
You can't choose according to your whims.
No.
That I'll settle with this gentleman, not with this. Settlement, entire settlement.
Well.
Then one can think of.
Well.
You filed injury report and all. Issue notice to opposite party number 2. In the meantime, on 19th and 20th June. In the meantime, petitioners to file the additional document. You have to file additional document. Yes. Bring the injury report and everything. And you examine whether partly in this type of cases can be quashed or not. Yes.
57.
My lords, I am appearing for the informant, my lords.
Why have you chosen these 2 people? Why not the other?
My lords, on mistake of fact, he has lost.
You are not going to decide this mistake.
My lords.
Why have you implicated them?
That's on by mistake he has apprehended.
You have implicated them. Charge sheet is filed. And after investigation, the police says that he is the main accused. Today you are compromising with these 2 people and leaving 3 of.
My lords, they were present.
What are the considerations? Either you have taken money or under threat you are doing it.
No, my lords.
No will not make. Why have you chosen these 2 only?
My lords, on mistake they have been implicated.
Then if you are saying that you are
wrongly
implicated,
my lords.
the consequence I will record that. They will prosecute you. You have wrongly implicated someone in such a serious crime. So you have to look on these issues also.
My lords.
Please check it up.
My lords.
Please check it up.
Very lordships.
And they take Mr. So-and-so APS for. Get some judgment where.
My lords.
It can be whether partially.
May I please, Lordship? I am appearing for VC.
Yes.
My Lord, this is a case of bail job.
1 minute, 1 minute. Yes, sir. You move application. Application. You application. Application. They move application. Application seeking adjournment. See, next date. Yes. Yes. 57. 57. Yes, sir. 57.
This is a bail job case. The date was posted on the 17th 11/2023. This petitioner along with two others were absent on that day, and they have the counsel for the petitioner filed a petition order 317.
But you tell me whether you are in bail or not.
I have already released on bail and during investigation after submission of CS.
8th February 23 is bail. And 17th November 23 is NBW.
500. Yes. First. Yes. Next.
58. Yes. 58 bail is on 24/9/2010. And NBW is on 27.
All this will be reconciled, and ultimately whatever is due to the contractor will be paid. And the advances paid is not for the work actually done. I will take a lot of time to ask more. My lord, so.
Either a very urgent, or there is no entry order.
No entry order is there.
No entry order is there, notes.
I'll give entry order and we'll hear it.
Let them move the application, notes. The
Have you
case
moved
has
the-
been posted. The case has been posted for framing of charge in the month of June, notes.
Have you moved application here? On oral prayer, I'll allow them to move application before court below for adjournment. Right now. Matter is ripe for final hearing. Due to shortage of time, the same cannot be heard today. In view thereof, petitioners are given liberty to move liberty to move an application before the court below, seeking adjournment. If such application is moved, same shall be considered, owing to the fact that the matter is subjudiced before this court. Move the application.
This order because individually needs because we different research.
How many petitions?
Mine is one, first one.
There is Sabure put to Dolgal Kakuri. Sabure separate order.
I just make a humble prayer.
Yes.
Just after vacation, the lordship picks up one date at 2 o'clock because it was
We
17.
fix up, they go 2 o'clock,
2007.
2007. I client to the.
Today, vacation, shall I lease it in the vacation? Shall I lease it in the vacation? Vacation.
No, vacation, I cannot be. Nobody will hear. Take up in area.
10th July, latest. 10th July. Before that is not.
June.
June compromise petitions are.
No, something short here.
Already
Sir,
around
आपको date चाहिए तो हमें check up करना होगा।
28 minute last.
You just coordinate with them.
क्या secretary date?
10th July.
We'll just check it up and give it.
Aye.
Yes.
Obliged.
It will be reflected in the order.
Yes.
60 Belgium matter.
Your lordship directed them to move application for.
Yes. You when you got the
not been a religion. It's arising out of it's on that case.
complaint case, NBW issued on 4/4/2024. Was 500. Yes.
61. 60 my order. 60 my order. Appearance my order. Someone issued to them, they did not appear for that.
Someone were issued to the petitioner. They failed to appear. Therefore, NBW issued. Next, 61. 61. NBW again 61.
Bail on 25/7/2022. NBW 2/11/22.
500. Yes.
62.
It's a Belgian matter. So the petitioner was released on bail by this honorable court on 21/6/2016. In bail.
1 minute, one minute. Yes. Tell.
The petitioner was released on bail by this honorable court on 21/6/2016. In appeal numbers 613/8/2015.
NBW 2009 31 से 1/2019 NBW हाँ 1000
63
हाँ 1000
It's a Belgian matter. NDPS issued on 10th April 2020.
Same thing, my lord. Someone issued and it did not, my lord.
Summons were issued to the petitioner. However, he did not appear. Therefore, NBW was issued on 10/4/2024, 5 hours. Yes.
64.
500. Yes.
65.
And 399/42 released on bail, arrested on 19 January 2030 and 11 April 2013 released on bail, 26/4/23 at the time of claiming charges. Additional
500. Yes.
66.
Was issued on 20th November 2006.
Bail.
No bail.
Complaint. Summons were issued. Did not appear. 500.
67.
नहीं कंप्लेंट कैसे पूछा 60.
2018. There was a 13/5/2015.
Fresh NBW has been issued on 19/2/24, so that may be the order to call.
19/2/24. NBW sorry bail on
13/5/2015.
13/5/2015. NBW on fresh वाला कब
19/2/24.
19/2/24. ठीक है. 7 yes.
68.
NBW on 13/9/2023. Petitioner is not out on bail.
Not
on bail.
Absconding.
সেটা কি দেখেই নি whether he is absconded or not, that is not. But the application of the bail order has been annexed by the other accused persons. In respect of other accused person, bail order has been annexed. But so far this petition is concerned, no bail order has been annexed.
You should be grateful that they have filed the petition. The time will come, they'll come straight away tell that to cancel the bail.
Sir, এটা পাস আউট করে কালে সেই কোর্ট বেলে থিবে যদি কইবে কিছু মু পিটিশন নে কোর্ট দেখিনি
খালি সিম্পল লেখো petitioner is challenging the order dated 13/9/2023 whereby the additional sessions special judge so and so issued NBW against the petitioner in GR case number 9/4/2008 pre-release. तापर लिख दो स्टेटमेंट ठीक है 500 ठीक
69.
This matter we can't please. Bail. Huh? Non?
69.
Give me the date. Yes, on bail. NBW on 17/11/500. Yes.
70.
500. Yes.
71.
The right petitioners 1 to 4 was put on bail on 17/9/2014. Petitioner number 5 was on bail 11/8/2015, and NBW was on 3/4/2020.
2022.
3/4/2024.
Okay. So 5 people are there. 2000. Yes. In total, huh?
Okay.
Yes. 72.
The mic is not working or what? Not working. Good.
And some religion were on
2020.
500. Yes.
73.
Lord, I am in virtual mode. May I please your lordship? Well, it's a complaint case. Well, after cognizance, after notice, my personal appearance was dispensed with by order dated 20 January 2022. Thereafter, my lawyer could not take steps, and I could not also file an undertaking for which NBW has paid.
Arising out of complaint case, pursuant to summon order, he could not appear. The NBW issued on 15/9/2022.
No, my lord, my personal appearance was dispensed with by the London Magistrate.
The personal appearance was dispensed with. No. So it's not necessary to write that. Yes, set aside. Yes.
74. What happened in 74?
My lord, one thing. My lord, in the meantime, I am told that a fresh NBW after this has been issued. So any subsequent order, that is recently that has been passed.
Nothing is there on record. You have not said anything.
No, that is not there. That is not there.
Then what can I do? That will cover. Yes.
In this case, my lord, your lordship will last time directed me to take instruction regarding health concern of the wife of the petitioner, my lord. And since election is going on in the Koraput, my lord, another date will be given for
least it is vacation.
My lord.
Least it is vacation. Yes.
75.
75 for modification of the condition. I have been inquiring on
Where is that condition? 27. Which condition?
Number 1. There shall appear before this court on each date of proceeding. Because
Only for that purpose I agree. On any day, because unless I appear, 317 they may not allow also. I have to appear. The petitioner, both the petitioners are parents.
Mr. Goda.
317, they will file 317, and as you know, when required, they will appear.
Your lordship may modify to that.
Petitioner agreed by the condition imposed by the court below while enlarging him on bail by order dated 31/1/2024.
Yes.
He agreed by the condition that he was bound by the court to appear before the trial court on each date of posting. Mr. Sujata Jana, then for the petitioner submits that this condition is taking away the statutory benefit provided under section 370 CRP. Therefore, he seeks modification of the said order. In that view of the matter, the condition is modified, and the petitioner shall appear before the court on the dates of posting, subject to petitioner filing application under section 317 if needs to arise. If needs to arise,
490 in-laws, father and mother.
Or she can avail the benefit of section 205.
ଆଉ ହବନି trial ଆଉ ହବନି
317 ହେଲା ଠିକ ଅଛି ଠିକ ଅଛି
ସେଟଲମେଣ୍ଟ କରୁନାହାନ୍ତି କାଇଁ ଖତମ
ସେଟଲ କଲେ
ମୋର କିଛି ଅସୁବିଧା ନାହିଁ ସେ ଅଦର ସାଇଡ୍ ଆସିବ oblige
76
allowed
76 copy notes are that is
non appears
and defects are there
as a line last time also non appear which means default for when the matter was called up on 21/3/2004, none appeared. Therefore, the matter was urgent for today in the interest of the seat. None appears. None appears today. Only our petitioner, and it appears that petitioner is not interested to prosecute the matter. Accordingly, it is dismissed. Yes.
77. Passing of FR
and same order. Matter was listed on 21/3/2024 none appeared. In the interest of justice, matter was adjourned. Even today, none appears. It appears is not interested. Dismissed.
78.
The modification of our data series 6/2022. The cost of the condition of the deposit of 20,000 of the cost of witness. The 4 witnesses are examined, and out of 4, one is
Which
hostile.
condition?
Justice.
That condition, including the condition that that he shall deposit an
20,000.
amount of 20,000 rupees towards the cost of the witnesses. Present and to be cross-examined.
4 witnesses have been examined. Man. Out of 4, one is hostile. 3 witnesses, cost is 20,000.
Then?
ଗରିବ ଲୋକ ଦେଇପାରୁନି ସେଇଦିନ 22 ମସିହାଠାରୁ ଇଏ କରିପାରୁ
22 ମସିହାରେ accept କଲେ ପରେ now
what do you want then?
ବେଲଜିୟମ ପାଇଁ ମ୍ୟାଟର ବେଲଜିୟମର କଷ୍ଟ ହେଇଯାଇଛି
20,000
cost.
How much you want?
କେତେ ଦବ
condition lower court impose ଯଦି
ହାଇକୋର୍ଟ ଦେଇଥିଲେ ହାଇକୋର୍ଟ ଦେଇଥିଲେ ମାନେ ହାଇକୋର୍ଟ ଦେଇଥିଲେ condition including condition that he shall deposit amount of 20,000.
Cross-examining is over.
4 witnesses have been examined.
What's the cost of the witnesses, madam?
Already examined, you have not paid anything.
No, all 3 witnesses are examined. One is a hostile minor.
By order dated 30th June 2022. This court had allowed the application of the petitioner and had imposed a cost of 20,000 rupees and directed the petitioner to deposit rupees 20,000 towards the cost of witnesses. Out of 4 witnesses, 3 witnesses have already been examined. And due to financial difficulty, he took modification of the order. In view of the submission before the court, the condition for depositing rupees 20,000 is modified to that of 10,000. Pay 10,000. 10,000.
6,000 3 ଜଣ ରିକଲ୍ ହେବେ 5 kilometers distance.
6,000. Yes.
5 meters hearing matter.
28. Hearing matters. 28 item.
128. Lordship need not open the file. My learned friend has filed an application.
After time
to file a counter.
So in Sirajuddin case, there 6 cases are there. Income tax department, matter, let me remember.
You want to file?
After vacation, let me any date.
Least it after vacation, entry order to continue. On the request of Mr. Party.
In July, first week in July.
On the request of Mr. Party, this matter on sunset, the entry order to continue.
But counter if any to be filed in the meantime.
In the meanwhile, you file.
Meantime,
And also start the copy of this.
Counter event.
Other side.
79.
May I please?
If such if the counter is filed by the opposite party, petitioner is granted, the petitioners are granted liberty to file rejoinder to Yes.
79.
May I please, madam? Madam, in this case, I paid the informant as the party, but by mistake, I have not made the victim as the party. So, am I allowed to write, implead the victim as the party OP number 2?
The counsel for the petitioner seek leave of the court to implead victim of the case party to the proceeding.
I want to take notice by special messenger.
She may do so within 1 week. If victim is implemented the opposite party number 3, notice be issued to him.
By special messenger.
By special messenger. Yes.
My IA is there in this case.
I will be there. If you installmentally keep on adding people, what can I do? Least the matter.
376.
Yes, next.
Item 80.
Madam, permit to withdraw my permitted to withdraw. Dismiss as withdrawn. Yes.
81.
Modification also the city case number wrongly typed as 773 by 2020.
Where, which order?
Your lordship's order dated 9/5/2024, your lordship.
City case number? Where?
Correctly as 733 by 2020.
Where it is mentioned, city case?
In the ordering portion, lordship glance the cost title. In the cost, my petition mistake, your lordship, in the cost title. It's my mistake.
But in the order, there is nothing, no.
There is
city
nothing,
case.
your lordship, but the court below, since it has been written in the cost title, given details of the case numbers, court below is not accepting that unless until it's correct.
What was this order?
The cost title page ଆଜ୍ଞା 763 by 2020 ଅଛି ସେଟା 733 ହବ.
Now, how do I know that both the cases are same?
It's my mistake. I file application for
No, no,
correction.
no. I have granted bail, it seems.
You know?
Have I granted bail in this matter?
No, bail, your lordship. By IPR before the court below, he allowed the remedy filing appropriate application.
GR case manner they have wrongly mentioned.
That is not GR, that is city case
City
number.
case, wrong city case.
Correct city is lordship 763 is 763 ହେଇଯାଇଛି ସେଟା 733 ହବ. PS case रा सब ठीक हो जाएगा. PS case court number everything is correct. Only the city case will wrongly.
Right. Petitioner removed his application seeking. And don't say that modification of the order then.
But correction.
Correction.
But in the order there is nothing.
Yes,
No reference.
correct, your lordship. I specifically said order ଆଉ ଗୋଟେ ଜିନିଷ ଅଛି କହିବି. ଏଟା କୋର୍ଟସ ବିଲ କହିଥିଲେ ଅର୍ଡର ଡାକିଲା ବେଳେ ପାରାଗ୍ରାଫ 5 ରେ ଏଟା କୋର୍ଟ ବିଲ ହେଇଯାଇଛି. ସେଇଟା ଖାଲି ଏସ୍ ଗୋଟେ ଯୋଡିବ. ନାଇଁ ହଜୁର କହିଥିଲେ.
Correction in the typographical correction in the petition. Instead of in place of city case number 733 of 2020, but in the petition as city case number 773 of 2020 is wrongly mentioned. Therefore, the petitioner seeks correction to that effect. The application is the city case number 773 of 2020 occurred in the petition shall be read as city case number 733 of 2020.
ଖାଲି କୋର୍ଟସ ବିଲ ଆଜ୍ଞା
Court below.
କୋର୍ଟ ବିଲ ହେଲା ଆଜ୍ଞା ଗୋଟେ ସେଇ ତଳେ ଗୋଟେ ସେସନ୍ସ ଅଫେନ୍ସ ଅଛି ଖାଲି ଏସ୍ ଟା ଆଉଛୁ ଟିକେ ଏସ୍ ଗୋଟିଏ ଏସ୍ ଛୋଟଟେ ଖାଲି ସେ ଲାଷ୍ଟ ପାରାଗ୍ରାଫ 4 ର ଅଛି ସେ ଅର୍ଡର ଖାଲି କୋର୍ଟସ ବିଲ ଅଛି ଟିକେ କହିଦିଅନ୍ତୁ ଲେଟ୍ କୋର୍ଟ ବିଲ କୋର୍ଟସ ବିଲ
Good S ଲଗେଇବା ପାଇଁ then you move application. You have not moved application. Where have you said that?
ସେଇଥିରେ ପ୍ରେୟାର ଅଛି ସେଇଆ ସେଇ ପିଟିସନ ଅଛି ଖାଲି କୋର୍ଟ ବିଲ ଜାଗାରେ କୋର୍ଟସ ବିଲ ପାରାଗ୍ରାଫ 4 ରେ ଲାଷ୍ଟ ଲାଇନ୍.
He further submits that in the order dated 9/5/2024 in the last paragraph. Last
paragraph 4
the paragraph 4
second third line
instead of quotes below.
Yes,
quote below has been written has been mentioned. The same shall be read as quotes below.
Duly obliged.
84. On say order on 30/2023 none appeared for the petitioner. Therefore, the matter was adjourned to today. Even today, nobody appears for the petitioner. Since the petitioner is not interested to proceed with the matter, dismiss.
85 disposable.
Dismiss for non-prosecution. Yes.
85.
Okay. The matter was listed on 17/1/2024. Thereafter, again, the matter was listed on 18/3/2024. On that day, none appeared. In the interest of justice, matter was adjourned for today. And even today, nobody appears. Same. It seems they are not interested. Dismiss. Yes.
86.
Permitted to withdraw, my lord.
Give him.
Yes.
Give him. Dismiss as now.
87.
May I please your lordship? My lord, I have filed this application for quashing the criminal proceeding against the petitioner, my lord, for the offense 294, 323, 506.
Why?
My lord, on the ground that the petitioner is a lady and the
You have not filed anything, sir, except the
FIR copy, my lord. And there is a compromise between the petitioner and the opposite party number 2, my lord. The petitioner is a lady and opposite party number 2 also a lady, my lord.
who all are the other accused persons?
No, only one accused person.
Both of them are lady. Where is the question of 376?
My lord, that is the, my lord, that is the
What is this?
FIR टा केवल फाइल करचंती ओनली FIR फाइल करचंती तार रोलटा देखा जो
जणे का खाली that lady is there.
my lord, only ladies.
Only lady.
ये नहीं थिला ये संगे नहीं थिला से जियो को तापर कोन करिची subsequently the statement of the victim must be recorded.
And my lord, there is also
376 N.
हाँ ये तार कोन अच्छी डॉक्यूमेंट देना खाली FIR दीजिए ना.
only FIR and also I have filed a affidavit, my lord, that is annexed 2, my lord, page 14, my lord. The affidavit filed by the informant before the Law and SDGM Bhadrak, my
Who
lord.
is filed it?
My lord, the informant, opposite party number 2, my lord.
What does he say?
My lord, Ambe affidavit
They
carry.
settled the dispute. They settled the dispute.
My lord, they have.
On that basis, bail has been granted.
Bail has been granted.
Issue notice to opposite party number 2, retainable instructions, and counsel for the petition submission. The parties have settled the dispute, and the opposite party number 2 has filed an affidavit before the court of SDJM.
Bhadrak.
SDJM Bhadrak.
Bhadrak, my lord.
Bhadrak in GR case number 33 of 2023 inter alia setting that she has settled the dispute with the petition. On that ground, he seeks indulgence of this court. Investigation is still going on. Investigation is still going on. Issue notice to in the meantime, no course of action against the against this lady.
Yes.
Lady 376. In the meantime, no course of action shall be taken against the present petition.
Obliged.
And the petitioner submit that he has been extending all cooperation to the police for the purpose of investigation.
Obliged.
89.
May I please? My lord, the petitioner challenged the order dated 25/8/2023, passed by Ronald James C. Hartman. Lords, we can see page 43, my lord.
What is this order?
Order page 43, my lord. Page law and APP, my lord, filed the under section 173(8) CrPC, my lord. The praise for the directing the superior police officer re-inquiry over the case and submit the supplementary charge sheet and proper manner give justice to the affected and add the under section 307 CrPC, my lord. Let's see.
Has he said that I led 307?
37.
Where is that?
Nine.
Has he said that?
Let's be the cognizance already taken, my lord. The cognizance offense under section, my lord, 341. 294, 323, 354, 506, 448, and 34 IPC, my lord. Charge sheet already filed, my lord. My prayer, my lord, not to add the under section 307 IPC, my lord. Not to 307 IPC, my lord, because the injury is the simple, my lord, simple, but the grievous injury, my lord. The ground, my lord.
No, simple or grievous?
Simple, my lord. 89. The allegation, my lord, the assaulted by the accused person by means by the core bar, my lord.
Cognizance has already been taken.
Cognizance already been taken, charge sheet already filed, my lord. The APP,
whether 307 is made out or not, you have to argue at the right stage.
It is made out, my lord.
Made out.
Yes, my lord.
You are for informant.
Last week only.
You are for informant.
Informant, my lord. Can take after vacation, my lord, to satisfy. Yes.
Page 48.
40.
48. 48.
Yes.
Second para. Now, with latest pronouncement in Vinupai Haribal Malviya and others versus State of Gujarat and other 2019 so and so. Honorable Supreme Court has endeavored to lay rest to the controversy involving the evasive issue of further investigation directed by the magistrate. The Honorable Supreme Court, speaking through Honorable Justice R.F. Nariman, has laid down at para 30 that to say that a fair and just investigation would lead to the conclusion that the police retain the power, subject of course to the magistrate's nod under section 173(8) to further investigation, an offence still charges are framed, but that the supervisory jurisdiction of the magistrate suddenly ceases midway through the pre-trial proceedings would amount to a travesty of justice, as certain cases may carry out for further investigation so that an innocent person is not wrongly assigned as an accused, or that a prima facie guilty person is not so left out. There is no warrant for such a narrow and restrictive view of the power of the magistrate, particularly when such power are traceable to section 156(3). Read section 156(1), section 2H and section 173(8) of CrPC, as has been noticed here in above, and would be available at all stages of the progress of the criminal cases before the trial actually commence. It would also be in the interest of justice that this power be exercised so moto by the magistrate himself, depending on the facts of each case, whether further investigation or should or should not be ordered is within the discretion of the London magistrate, who will exercise such discretion on the fact of each case and in accordance with the law. It was also clarified.
Reject it.
Yes,
Reject it.
yes.
Can't
Very clearly mentioned that.
You are not agree.
No, this can be taken care of in course of investigation, because in course of a trial, because the section 319 is there. If supposing my lord alternation of charges is there in the
The mention is just and fair investigation. Just a just and a fair. Yes, ma'am.
Can you hear the court?
Yes.
Your biggest problem is you are the informant. You move the application through the public prosecutor, which has been rejected.
Yes.
The public prosecutor today is not supporting you.
My Lord,
What to do? Tell you.
Yes, can you see order 47 page, my lord?
He says that this order is perfectly all right.
No, my lord, we can say fair, just and fair and investigation, fair investigation. Lord, we can see page 47, my lord. Page 47. After consideration of the statement of the witnesses under section 161 CrPC.
The trial court has taken note of the Supreme Court judgment and says that if any evidence will come eventually during the trial, 319 is there.
No.
That's what the court says.
Why can taken up after vacation on the satisfied, my lord.
After vacation,
yes.
Do you expect that some other Supreme Court judgment will come?
No, yes, my lord. Satisfaction karibi.
Charge sheet is filed, trial is going on. And
that is the discretion power of the magistrate.
You moved an application under 173(8) through PP,
yes,
which has been rejected by noting a Supreme Court judgment. And PP is not supporting you today. What to do?
See, kotha satisfaction kari my lord. Kumu vacation 18 तारीख.
July लगा दी.
July. ए बेस भी देरी. 20 तारीख रे रहो. 20 18 के 20
time नहीं बहुत heavy होता. Metric is next.
91.
May I proceed? Modification of order, my lord. Proceed, please to on 23/4/2024. Order was 23/4/2024. Order was passed, issue notice to the informant and stay of further proceeding in GR case instead of CP number, my lord. Last order sheet. In the interim, further proceeding in CP number 20 of 2023 pending the court of law and judge family court Jagatsinghpur shall remain stayed. GR case number. Instead of CP.
No, it's all right, but after taking this interim order,
yes.
Next day you didn't appear. None appear for the petitioner.
I am in VC, my lord. I am in VC in the 9th, my lord. My daughter was
therefore I listed the matter today. Adjourn and so interim order to continue. Yes.
No, interim order, my lord, correct. ठीक है, CP number भूल ही थी.
Where is your application? Have you moved application for modification?
Yes, I.
Where is that?
Yes, I.
Where is that?
Yes, ma'am.
Where is that application?
1180/2024. I.
CP number 20.
Yes.
It should be CP number 20.
No, it should be GR case number. GR case number 333. GR case number 333 of 2021 pending the file of Lawrence JMFC Titol instead of CP case number. भूले CP टा हेगला CP टा dispose of हो जाइसी.
Acha. Entry order dated?
Entry order dated 23/4/2024.
The entry order dated 7 paragraph. 23/4/2024. So para
7.
7 in place of CP number 20 of 2023, it should be GR case number 333.
2021.
21.
333 pending in the file of Lana JMFC Tirthol.
Pending in the court of JMFC
Tirthol.
Tirthol. Change order.
Oblast.
Yes.
92.
Yeah.
Last occasion, your lordship, sir, direction of notice through IO.
Yes.
Copy. Extra copy ta dena
On in court, Mr. Ragada received.
We have already sent a letter on 16/5/2024. Election time is
awaiting instruction. Yes. Next.
93.
18.
Noting is there.
Yes.
Postal tracking report of.
Yes, madam.
And 93 members.
I didn't follow you.
There is a noting, my lord.
Yes,
90.
please, service. Service on opposite party number 2 is sufficient. However, non appears for opposite party number 2 in the interest of justice. Yes. Next.
95.
20th ko, my lord.
Yes. 95.
95 minute, I have instruction to appear on behalf of opposite party. We'll thank our Wakalat by tomorrow.
So entered appearance for opposite party number 2, non-appears for the petitioner in the interest of justice.
96.
Same.
96.
95 and 95 for the complaint, the petitioner also.
Petitioner, I place non-appears. Yes. 96.
96 same.
Same. 95, 96. Same.
So entered appearance and 6 that adjournment. So detail.
97.
compromise ground file करछनी, no injury report, no charge sheet.
Right. The matter was registered on 29/1/2024. Adjourned to again adjourned to 11/3/2024. Thereafter, matter was taken up on 15/3/2024. Non-appeared today on behalf of the petitioner. It appears that the petitioner is not interested to proceed with the case. Dismissal.
98.
Please, Your Lordship. Your Lordship, I filed one IA 1286 of 2024 for amendment and to add the petitioner number 2 and 3. Matter is that, Your Lordship, now going for settlement under the compromise, Your Lordship. So I pray, Your Lordship, kindly to.
They are the accused person. How many accused?
No, this is a FIR and counter FIR. The another FIR has been
The
already.
other two petitioners you want to implead.
Yes.
They are accused in the same FIR.
No, not in the same FIR. That is another FIR.
Then you file separate petition. Tag it with this.
That, Your Lordship, what happened in this case, Your Lordship, they have added the case, Your Lordship. I have last occasion, Your Lordship, directed, and I have.
There are two FIR.
Yes.
Both are cross FIR according
Yes.
to you. And the two people you want to implead, they are accused in that FIR. File a separate one, get it tagged.
In this case, Your Lordship, because of what happened in this case, only we have made the party to the petitioner who is an informant. And in another case, Your Lordship, that is, I have already.
Another case, for another case, you have to file another petition.
No, that is already quashed, Your Lordship.
Then?
That has been already quashed by the coordinate bands, this one also.
ODR कौन सा? ODR कौन सा?
In CLMC, I would case already quashed his section. You'll also that is CLMC number 2138 of 2023. That I have already annexed to your lordship.
ଆପଣ ଏଥିରେ କଣ ଚାହୁଁଛନ୍ତି କହୁନାହାନ୍ତି?
ଏଥିରେ your lordship another data petitioner को add କରିବା ପାଇଁ ଚାହୁଁଛି. They are also in.
Who are they? These two petitioner you want to add these two Ritesh Barik
and
Sanjay Kumar
Sanjay
Barik.
Kumar Barik.
Who are they in this petition? In this FIR? Are they accused?
They are also accused.
That's what I'm asking. If they are accused along with the present petitioner.
Present petitioner.
Simple you answer.
Yes.
This case, that case. What is this? Right on. The petitioner has moved the present application seeking to implead one Mr. Ritesh Barik and one Sanjay Barik as co-petitioner. As a co-petitioner, co-petitioner. The application is allowed. Petitioner is granted liberty leave of this court to add Ritesh Barik as petition number 2 and Sanjay Barik as petition number 3. If the petitioner submits, counsel for the petitioner submits that the matter is already settled and leaves the matter on such. Yes.
You also may say one thing. You also, if lordships permit, then we kindly call for the matter tomorrow. They all will be present before your lordship, so it will be settled the matter.
Thank you very much for the grace. That
It's my
item 16. We are not waiting for them. If they come, they come.
No.
Whenever they come, we'll do it. Okay.
They are ready for.
They may be ready. Why have not come? They should have come anyway. Tomorrow not possible. Yes.
Item 68, my lord.
I also.
What is the stage?
That is
What
trial.
is the stage of trial?
Trial is going.
You move application. Submit that you move application for adjournment in view of the fact that the matter has already been settled. If such application is moved, center will consider. Yes. Next.
High level.
102.
98 copy may be served.
98 supply copy.
CLMs का भी नहीं आइए कॉपी डाइट
अरे सब गुड़ा को दियो ऐसे आर्गुमेंट करले फायदा ठीक है आप ही आर्गुमेंट यस
Leisure.
yes sir
99
102.
100
CBI. Lords, here the petitioner has come up against an order of the court below, rejecting his prayer for being discharged.
so it will take little time.
Only short point, your lordships.
Short point but big lawyers.
Sir is a big lawyer, your lordships, but I'll take only 2 minutes.
You are a bigger one.
I'll take 2 minutes, your lordships. The only point of
he is the petitioner. He will take little more time.
I'll take some time.
So I'm just adjourning it and then let him move an application for adjournment. Let him move application during vacation. Why to create problem?
July, your lordship.
July. The matter is ripe for final disposal. Due to shortage of time, the matter could not be heard. In that view of the matter, then counsel for the petitioner submits that he would move application before the court below, seeking an adjournment, owing to the fact that matter is sub judice before this court.
There is an interim order, so that will
already.
Aye.
So then, where is the interim order?
Interim order was passed first on 4/1/2024, and that is continuing.
4/1, there was no interim order.
There was no interim order actually.
No.
But by mistake, your lordship said that interim order should continue. Initially, there was no interim order.
4/1, there was no interim order, but subsequently interim order to continue, interim order to continue. There is no interim order.
No, your lordship permitted that I will file a petition.
Where is that?
That I have noted on 4/1.
But there is, in the order is not reflecting.
Let it come in July.
July, and now I am making that order. Okay. Yes, now I am July. Here.
103.
Yes. 103, there is anyone?
No one.
No one. None appears for the petitioner, interest of justice, adjourned. Yes.
104.
My lord, modification of order
Which order?
23/4 to 2024. Only city case year is wrongly typed. 23. City case number 274 2023. Sir, ହେଇଯାଇଛି 21.
କୋଉଠି କିଛି
Order portion ହେଇଯାଇଛି. Cost title ଟା ଠିକ ଅଛି.
अरे भैया सिटी केस 2021 लेकिन इसकी 2023
Number ଠିକ ଅଛି.
21 जाएगी 23 हो ठीक है
Public.
यस तो देखिए ऊपर यस नेक्स्ट
105.
Sir, by next week I file the requisite.
Next week?
By next week I file the requisite.
requisites you have not filed.
No, ma'am.
The counsel for the petitioner that she would be filing requisites serve opposite party number 2 and 3 within a week urgent. Yes.
107. 107, my lord, I am on behalf of Mr. Om Surup. His grandfather expect today. I pray for an adjournment.
There is a bill pending with him.
I'm after. My lord, may I please?
Yes.
Ma'am, my lord, in 107, I am appealing for the OP number 1.
Yes.
I'm appealing for the OP number 1 in 107.
OP number 1 के appealing.
I filed local and one the registry.
Yes, yes. Urgent. Entry mode to continue.
Interesting question. 108.
108.
This correct address will be provided. This correct address will be provided.
Petitioner is directed to provide a fresh current address of the opposite party number 2 within a week. Urgent to some. Yes.
109.
Conversion to revision.
Sorry?
I filed an application for conversion of the application from miscase to
Counsel for the petitioner, petitioner is moved an application for conversion of the present application to that of revision. The application is allowed. The is directed to convert the present petition to a revision petition and assign a number and list before appropriate bench. Yes.
110.
Before after vacation.
After
No, what happened in this case, my lord? This matter disposed of, my lord.
No.
On
See,
28/5/22.
No. Let's see, kindly see the order. CRLMP, restoration the justice AK Mahapatra. Let's see, kindly see the order.
Copy of Naik.
After vacation.
After vacation, and entry order may be continued.
Entry order. Ask it. Yes. Next.
112.
Yes.
Petitioner is the husband. Petitioner is the husband.
12.
My lord, opposite party wife.
What is this matter? So
DV
many
case.
hearing.
My lord, your
1,
lordship
2,
and
3, 4, 5, 6, 7,
in the-
8, 9, 10.
my lord, washing of that proceeding, my lord, there is a, it needs some time. Your lordship, the marriage was solemnized in the 2015. Petitioner is, my lord, we will a constable, my lord. In the opposite party occupied my quarter, my lord. She is now residing. It needs, my lord, some time. Your lordship, Arjun, any date after vacation, I will.
Stay be vacated.
No, 8,000, my lord, I have paid.
Last day of the vacation.
My lord, what happened in this case, your lordship will find that DB proceeding has been stayed by virtue of the order dated
Maintenance is being paid or not?
8,000 regularly paying. I am paying. Just
You are
if
getting
not, if
maintenance?
not paid, then your
Getting
lordship will
maintenance.
direct. Conditional
Pay,
order.
Vacation, nothing.
Since August 22, the DB proceeding has been stayed by virtue of the.
You are subject to paying the maintenance.
I am paying my lord.
Is
I am
paying
paying
8,000.
regularly. Your lordship
I
will.
filed an enhancement application. The court bill has rejected my application, saying that since the stay order is continuing, I will not consider your application. Because my child, the only girl child out of the wedlock, is now admitted into school.
Your enhancement application is pending.
No, that has been rejected by the court below.
Then you challenge that order.
That I have to prefer an appeal. But here in this application, the initiation of the DB proceeding is under challenge. So my submission in this case that order is also appealable under section 29 of the DB Act. However, this present application will be.
I am paying. Your lordship urgent the matter after vacation any date, my lord.
Any order passed by
What he says is,
my lord,
you are challenging the DB proceeding.
DB proceeding, my lord.
And a specific provision is provided under the.
My lord, your lordship is right. Appeal is there, but I am not on any appeal is against any order passed by the under the DB Act. I am challenging the DB proceeding is not maintainable, my lord. Only the, and so far as 8,000 concern, my lord, the Lord Court below, I am paying regularly. Your lordship may pass. If I am not paying regularly, my interim order will
My lord, may
happen.
kindly see the 29, section 29 of the PW.
No, he says that the proceeding itself is not maintainable.
Maintainable.
Proceeding, any order passed by the magistrate, after getting the summons, he has.
He is not challenging any order.
No, my lord. Initially, basing on the report of the wife, the protection officer has referred the matter to the magistrate. That there exists domestic violence on her. Basing on that report, a case has been initiated and summons has been issued.
Have you moved application before the DB court that it's not maintainable?
No application.
I will not say anything. Only I'll give liberty to him to move an application.
Yes.
If such application is moved, the trial court will decide the application. Okay. Let us see the outcome.
Yes.
I will maintain liberty.
Yes.
In the meantime, right now, the petitioner has challenged the entire proceeding initiated by the 1 minute. I pass a balance order. Initiated by the opposite party under DVX, under DVA. DVA. This court has when it was stayed?
It was stayed on 25/8/2020.
This court, while issuing notice to the opposite party, stayed the proceeding before the
Will be proceeding in 1/8 of 17.
Proceeding before the court below, insofar as the DB proceeding 218 of 2017 is concerned. The counsel for the opposite party submits that the present petition is not maintainable. In fact, an appeal ought to have been preferred under section 29 of DVA. Without going into the length of the case, the petitioner is directed to move an application for application regarding the maintainability of the DB proceeding before the court below. If such application is moved, the same shall be considered by next date of hearing by the court below, by the court below. Matter be adjourned to present that day, and the interim order shall continue. Interim order will continue. Meanwhile, you move an application, get an order from there. You oppose that. If that is dropped, then I will next date of hearing I will drop this matter.
And the another application has been filed that is with matter.
That is
1012 that is challenging challenging passing of the affair.
That is my
No, in this matter I am saying. The other matter simply
Arjun, my
entry order to continue. What I have done is
there was no.
What I have done is the interim order as it is I am not touching.
Yes.
I am only permitting him to move an application before DB court saying that this proceeding is not maintainable.
Yes.
If such application is moved, let the trial court pass an order Next time if we drops, then this petition is
Section goes.
infracted.
Well.
If he doesn't drop, then we'll examine it.
But
And you have all the liberty to argue and go and
yes,
say that.
I will argue, my lord, any order, your lordship will kindly see 29, section 29 there, any order.
But you
passed
don't
by-
understand the idea of my order. If some
I-
order is
I
passed,
have-
then I'll relegate him to 20. I'm saying that.
I understand.
Yes.
But the with item, he also challenging the GR case.
Yes, that is simply, yes. Entry mode to continue. Meanwhile, you move application.
Yeah.
Yes.
113.
Your lordship, after
After application.
and then it's mobile application within 4 weeks.
No, immediately you do it. I'm listing it on July.
That
Why? Before next date appear.
in the meantime, vacation is, my lord, so I have to file application.
July I'm listing
books are
vacation is
open, man.
open. Trial
Human
courts are
books
open.
but only pen and paper.
You do it, let us.
By producing this order, court will take up them.
Yes. You move up. Yes.
113.
13.
Well, as these are proceedings for quashing of criminal case, my lords. I am a road contractor. The complainant in this case is opposite party number 3, Central Bank of India. Well, as the crux of the allegation was that I had taken a loan and I had failed to repay the loan. Basis that Central Bank of India went to CBI for registration of a case. A case was registered. Well, all this while talks were on for one-time settlement. Sometime after the filing of the FIR, one-time settlement was entered into and the entire OTS amount has been paid. In the meantime, CBI has filed a charge sheet, my lords, and I have filed this quashing petition. I'll give certain...
What is the stage of the trial?
My lords, nothing has moved, my lords, at this point. Cognizance has been taken, but nothing there.
Charge has not yet.
Charge has not been.
Yes.
I'll just point out, my lords. There was a 2-lane work which was, there was a
But you are
tender.
against the cognizance order.
My lords, I've challenged the charge sheet as well as the cognizance order. Both.
Why don't you argue all these things before the...
I'll point out, my lords. My lords, the judgments I'm relying upon, CBI versus Nikhil Merchant and CBI versus BB Agarwal, where there were public sector banks involved and there was OTS and thereafter quashing had happened. My lords, there is another aspect that these offences are non-compoundable. So if it is the trial court, my lords, they are bound by section 320 CrPC.
I'm not asking for compounding. I'm asking for argument on the question of charges.
My lords, I'm not on the charges, my lords. There are 2 judgments, my lords, that I'm relying upon where OTS has been done between the bank, the complainant, and the accused. In those cases, my lords, proceedings have been dropped. So I'm citing 2 precedents where
Irrespective of the fact that you have indulged in forging document and all.
no forgery, my lords, no allegation of forgery. There's no 467, no 471. I'll point out, my lords, from those cases.
It is only for
420, 13(1)D because a bank official has been made an accused, and 120B.
That is the problem.
There's no forgery, man.
20B is there and 13(2) is there.
Yes, ma'am.
That's the
Nikhil Merchant, what is the second case you said? Nikhil Merchant and?
Second one is CBI versus BB Agarwal. Also, my lords, CBI versus this Sadhu Ram Singla.
It seems it will take little time. I'll take it up after vacation.
My lords,
Because today is may not be possible, 4 o'clock.
my lords.
Oh.
Would it be in June, my lords?
June only.
June only.
June. Immediately the opening. Give a date to see. June we can adjust.
There's
Yes.
one more indulgence, my lords. Could it be a fixed time, my lords? Sometimes it's very low on the board and it has not
Next
reached.
time, see, depending upon the board, you know.
My lords.
Today is in any case, because of the last working day, this happens. We'll see. But keep it 3 o'clock.
Your Lordship, your Lordship, they did it after 21st June.
21st June, of course. 21st June for a 3 o'clock. Okay.
114.
I'm so grateful, my lords.
And prepare a written note and.
I will, my lords. I will. In fact, I'm carrying it today also, my lords. I'll tender it.
Yes.
My lords.
The copy may be given to me, Your Lordship. Your Lordship, a copy may. Yes.
Yes, yes.
I'll give it, Mr.
I will record it then. Let count for the parties are directed to place the written submission along with the relied upon judgments. Relied upon by next date. Yes.
Very well, my lords. I'll do that.
May I please, Your Lordship, my lord?
Yes.
114.
Here, my lord, I have filed this application for quashing the entire proceeding of city case number 858 of 22. My lord, on the ground that the petitioner and opposite party number 2 are both her husband and wife, my lord. and there was the husband filed a divorce case, and in divorce case the wife did not contested, and that divorce case was allowed, and thereafter he filed an application. Sorry, my lord, they lost an affair against the petitioner, my lord, who is the husband. my lord.
What is the service position?
Pardon, my
Service is complete. Unappeal for opposite party.
lord, service already complete. Notice already sufficient.
Right on. Despite service on opposite party number 2, none appear for the opposite party. In the interest of justice, urgent to sanction. In the meantime, we further proceeding in so is court. We stay. Further proceeding stay.
Obliged.
116.
Yes, sir.
Malus. In CRLMC 4290, my lords, I have challenged order of the special judge taking cognizance.
You have an interim order with you.
It is an interim.
There is an interim also.
Here, my lord, cognizance order has been challenged. Prior to that another matter has come, CRLMC 3473. In that 205 petition was rejected.
That 205 now. It can
That
be
he can approach and file an
Now,
application.
recent judgment.
I have not gone through that.
No. What Supreme Court says that once someone is issued, 205 can be allowed. That judgment is there.
205,
Where is that judgment? I passed today also. I passed.
Subject to furnishing bond.
Subject to 23, para 23.
Subject to furnishing bond.
Para
Yes,
23.
in the light of that judgment.
Instead
Yes.
of writing one paragraph, why should I get into all this thing? Now this judgment, they see, they directly now, that is diluted.
Let them come after the vacation.
No, that I am allowing that. 205 I will allow, and this is the urgent.
Yes.
Where is that 205 thing?
205, yeah. I have given.
3473 of 22.
That was in item number 4.
No, 3473
of 2022 is the matter relating to
3473 of 2022.
Okay, right down. Petitioner is agreed by the order dated. Order dated.
Order is dated 15/9/2020.
Next one, 15/9/2022, passed by the special judge CBI 1, additional sessions judge Bhubaneswar, in criminal miss bracket PMLA case number 8 of 2022, whereby his application under section 205 CrPC has been rejected. In view of the judgment,
Criminal appeal number 2608 of 2024.
In view of the recent judgment of the Supreme Court.
Criminal appeal number 2608 of 2024.
Particularly in view of para 23.
No, your lordship may say in the light of that judgment, because
the impugn order is set aside, but petitioner is directed to move a fresh application before the court under section 205 CrPC. If such application is moved, the same shall be considered in the light of the so-and-so supra, light of para 23 of so-and-so supra.
No, my lord, not 205. He is to first file an application for submitting bond. He is to personally appear, surrender.
He has to move application. 205 application.
Your lordship has said he is to file an application under 205 plus
only application.
Yes, my lord.
Okay,
Otherwise, he will not.
No, you are covered, don't worry. If any problem, then you come. We are directly covered.
Bond, yes.
Your case is directly.
If your lordship will write 205, he will not appear.
And what he is trying to find out, one paragraph is directly said that 205 should be allowed. And there are two other paragraphs you want to take.
No, my lord, not other. They have said he must appear, give a bond, then 205, which I was submitting earlier.
That too. 23
yes,
D is very clear.
No, 23D, and subsequently they have also
whether
said.
It is contingent upon the other paragraph.
EFG also they have said, my lord, he is to give a bond also.
Anyway, that's in view of the recent judgment, they have
he is to file an application, and yes. If your lordship will say
extra copy achi.
If your lordship will say 205, then he will not
only application.
Yes, my lord. He is to file an application, and that in that matter also Item 4 also your
My
lordship mentioned
respectful submission.
only application.
My respectful submission is this. If I appear, whether I appear through counsel or whether I file.
Everything is clarified, sir, here.
Everything is clarified.
Everything is clarified.
But the question of filing 205 doesn't arise thereafter.
Just see, the application, it says, in a case where the accused appears pursuant to a summons before the special court on a sufficient cause being shown, the special court can grant exemption from personal appearances to the accused by exercising power under section 205.
Yes, but what do their lordship mean by this? That appearance is through counsel, not through bond.
That you will tell them.
No, I'm reading. Your lordship said, I am reading the same thing. This is my understanding of the law. It is not what Mr. Agarwal says is the law.
No, I am not saying what Honorable Apex Court has said. I have not said.
205 says, and what the Apex Court says is appearance. And
Appearance through.
No, appearance cannot be stretched to say that appearance in person. That is my submission.
Yes. Take it.
So, as per this, I will do
Set aside and allow.
And the other one, my lords.
সকালে কপি দিতে না
সকালে আপনি কপি দিয়ে দিলেন সকালে আমি ওটা কপি দিয়ে আইছি থাও
কোর্টে থাও বেশি আছে yes মানে both the cases no good only other matters are simply urgent entry mode to continue only 3-4
in that matter there is no interim order, my lord. There is a cognizance order
5/4/2023 that a petition for adjournment may be liberally considered. I want that to
second don't today also you committed mistakes. Second one 3473
data disposal.
How other matters adjourned interim order to continue
4290
yes
117
ଆଜ୍ଞା ସେ ଯୋଉ ଇଣ୍ଟ୍ରିମ ଅର୍ଡର ଆଉ କିଛି ପର୍ପସ ହବନି ଇଏ ଅର୍ଡର ନା ହି ୟୋର ଲର୍ଡସିପ ଅଲସୋ ନା ଇଏ ଅର୍ଡର ଯୋଉ ହେଲା ଇନ୍ ଦ୍ୟାଟ ଅର୍ଡର ୟୋର ଲର୍ଡସିପ ହାଜ ପାସ୍ଡ ଅର୍ଡର ଇଫ ହି ଫାଇଲ୍ସ application for time
ବୁଝିବା ଆପଣ ଏଠି ବୁଝାନ୍ତୁ
if he files an application for time the court will adjourn the matter.
He can't file two application one adjournment one
he cannot ସେଇଟାକୁ ବୁଝିବା ସେଠି ଆଜ୍ଞା that court will understand
vacation ରେ
ମୋର କିଛି ଅସୁବିଧା ନାହିଁ
ମୋର ବି କିଛି ଆଜ୍ଞା ଅସୁବିଧା ହଉନି
that
ଆଜ୍ଞା ମୋର କିଛି ଅସୁବିଧା ହଉନି
problem whether he choose to move application for adjournment or
that's true because there will be two order on the same day there will be two order
ସେ କଣ ହବ ସେଇଟା ଆମେ ବୁଝେଇବା ସେଠି ଆପଣ କାଇଁ
vacation ରେ
ମାନେ ଆମେ ବ୍ୟସ୍ତ ହବାର ନାହିଁ
ଆଉ ଆମେ ବ୍ୟସ୍ତ ହେଇ ପଡୁଛୁ
170
ମୁଁ କାଇଁ ବ୍ୟସ୍ତ ହେବି
Yes. Lord, here in this case, my application for defreezing the account that has been rejected on the ground. I have already filed the requisite.
Tracking report fact be stating that
already
deliver confirm, my lord. But I have
they have to take instruction.
Somebody may appear, my lord.
Rejected on the ground that investigation.
OP2.
Rejection was only on
1 minute notice to
deliver confirm कर दिया जाओ. Sufficient.
Despite sufficient notice on opposite party number 2, non-APS in the interest of justice, urgent.
And also, State Council is directed to take instruction because
Mr. Ragada,
last occasion I have extra copy solved also.
Ragada submits that he is awaiting instruction in this case. He may obtain instruction by next day.
A date will be fixed.
Please.
120
Lordship, on behalf of Mr. A.K. Jena, pray for next week after vacation, Lordship.
Yes, next week.
And meanwhile, the
next week
victim may be
next week.
Victim may be impleaded as a party.
You want to implead?
Yes, Lordship.
Since he cleave up the court to implead victim at opposite party number 3. The prayer is allowed and petitioner is granted liberty to implead victim as opposite party number 2. Issue notice to opposite party.
Yes, sir. Obliged.
Yes.
121.
Yes, madam.
How interesting.
121. Non-APS.
Item 121.
Huh?
121.
Mediation center ku jaitila report ta asche, that is in flag.
Ahirani.
Yes, sir. Mediation center report is flag C. Flag C is the mediation report.
That is coming in attacking mood.
No, no, Lordship. In
Yes.
fact, concession fail kari jayichi, let it come after vacation, so it can be on merits, we can argue for a moment, Lordship. In the meantime, perhaps
The mediation failed.
failed, Lordship. So, kanta bahar zero,
Mediation,
bahar thik.
the matter was referred to mediation. However, mediation was unsuccessful.
Lordship.
Leaves the matter for hearing after vacation.
Lordship. Interim order, Lordship.
Interim order to continue. Yes.
Grateful, Lordship.
123.
For quashing of the Annexo 1, the entire proceeding on the ground, your lordship was.
After vacation,
How?
the matter is ripe for final disposal. Due to shortage of time today, the matter is adjourned to such day and interim order to continue.
Oh, bless.
124.
Milord, in fact, I have served the copy on Mr. Bhanjadev, Milord. The hard copy I have served on Mr. Bhanjadev.
Did they have solved the copy, my lord? Okay, yes.
What to do? It needs hearing.
Lordship may keep it after vacation, Milord, any day. So I am suggesting my learned friend, Mr. Bhanjadev, Milord. Can it be on 21st of July, Milord?
Yes, of course.
Yes.
21st no.
July, an interim order to continue.
An interim order.
No, all these three cases.
Interim order dated
July, 21st July.
Interim order dated 12 to 2024.
22nd July.
Shall continue. Interim order passed on 12 to 2024 shall continue. Till next date of it.
125.
Milord, in fact, the interim order, the 12th of February was for two matters. And in the other matter, interim order was passed earlier, Milord.
Don't say anything. Interim orders to continue.
To continue. Yes.
That's your right.
Quite fine, Milord, quite fine.
Thank you.
I think 21st is a Sunday, the best 22nd.
You have chosen Sunday conveniently what to do.
July.
125.
125 minute questioning that.
I will, I'm sorry, I can't hear this. I can't hear this better because for my personal reasons. I must tell you this for the wife, I think
Maybe.
in Delhi he has filed
Yes,
something.
yes.
My wife has appeared for some time.
Yes, maybe.
Please leave the matter before some other bench, subject to the permission from the Chief Justice. Be sunshine. Interim order is there?
Yes, madam.
I can't do it. Simply. Just immediately after.
Interim order to continue.
I can't say continue. I can't continue. Simply, yes.
127.
128 Yes, sir. Which matter?
I mean 139. The London Government Council says time
Somebody, my lord, in the morning, my lord, taken time, my lord. For that, I am.
And it is injustice to me is to impose with cost.
You might have enjoyed the court proceeding. He is, I think the other side is very scared of you. So therefore, that is the reason.
Settlement aji କହିଥାନ୍ତି ଯେ ଚଳ ସେଠି ପାରୁନି ଟିକେ ସେ ତା ଟିକେ fluctuate ହଉଛି ବୋଇଲେ ଏଠି consolation ପଳେଇଲେ 138 ଟା 63,000 involved ଆଜି ଯଦି ରହିଥାନ୍ତା ମୁଁ କହିଥାନ୍ତି
Anyway, no problem. Yes.
127.
127.
Lord, here I am telling the order of cognizance, your lordship. My lord, this case, your lordship, covered by your lordship judgment, your lordship. Last occasion, your lordship.
Which one?
My lord, last occasion I submitted to the. My lord, the NDPS case 20P2C, your lordship, where the chemical examination was not submitted, report was not submitted, your lordship. And meanwhile, the co-accused also acquitted by the land.
Yes, or no?
But yes, that one it's covered. I checked the judgment. It's covered.
They already given.
Right on. Petitioner has challenged. the criminal prosecution initiated against him. You have challenged the cognizance or what is this?
My lord, cognizance.
A petitioner has challenged the order
My-
dated 13/9/2022 passed by additional decision secretary cum special judge Pulwani in city case number 13 of 2022, whereby cognizance for offence under sections
20B2C and 27 of NDPS Act.
20
B2C,
20B2C and
27 of NDPS.
27 of
NDPS.
NDPS. 29 also? No.
No, my lord, 27.
NDPS has been taken against the petition. How many accused were there?
My lord, 3. Total, my lord, 6 accused person. This I filed for
And
3.
acquitted,
1 accused person has been acquitted.
right. There were 6 accused in the present case. One of the accused person who was apprehended undergone the was put to trial.
Namely, Kalia Conher.
Put to trial. The special judge Pulwani, by its judgment dated 5/5/2023 in CT case number 13 of 2022, recorded an acquittal in favor of the accused person, namely, what is his name?
Kalia, K-A-L-I-A.
Conher.
Conher, K-A-N-H-A-R.
In the acquittal, the state accused was acquitted on the ground that the prosecution could not prove the case, prove the case. Apart from that, it has come on the court that the prosecution is not even placed on record the chemical examination report. Which paragraph was that?
My lord, page 16, paragraph 17.
Page
67, paragraph 17.
The trial court entry India. Where 67, trial court in which paragraph?
17, my lordship.
17.
17.
The trial court entry India in para 17 of the judgment. Para 17, page 67. Page 67. Page 67. In view of the aforementioned judgment, the petitioner submits that subjective to the petitioner to criminal trial would definitely be a futile exercise. Therefore, he relies upon Gyansing, paragraph Gyansing, link charge of in the similar circumstances, this court, which of judgment, the court, this court, while allowing the criminal MC number 279 of 2023, Rakesh Chandra Sahu versus State of Orissa, and has allowed quash the criminal prosecution from criminal prosecution. While criminal prosecution, relevant would be to reproduce the para 6 and 7 of the case. Para 6 and 7. Number 3. Wide order dated 6/3/A4 taking into consideration the aforementioned, I am inclined to allow the petition and the criminal prosecution initiated against the petition and the cognizance order dated 19/9/2002. 13 or 19?
13/9/2022, lordship.
Passed by the additional district and sessions judge special judge Pulwani in city case number 13 of 2022, who the present petitioner quashed. Yes.
Highly grateful, my lord. My name name may be reflected.
Your name will be reflected and pay cost subject to petitioner paying 5,000 cost to bar association. You were absconding, therefore 5,000 to bar association. Okay.
I'll get full, your lordship. Oh, please.
Yes.
131.
It's one. Your lordship said called for the CD that has not come.
On the last date of hearing, CD was called for. But Mr. Behra, no Behra, then comes for the states submits that he has not received the CD adjourned. Yes.
Lordship, on the last occasion also directed to serve the extra copy. I'm
Yes, sir.
serving the copy.
Yes. Next.
132.
So in this case also, my CD has not come.
Everything CD adjourned.
Lordship, I'm serving the extra copy also.
दुईटा अगर मैटर लिख दो एक्स्ट्रा कॉपी शर्ट
So
137.
Lordship, I'm appearing through VC. Kindly adjourn this matter. Let it come after vacation.
थैंक यू adjourned.
136, Lordship, the reopening week.
No? Yes. Next.
138.
May I please, your lordship?
Yes, sir.
Your lord, the petitioner is challenging the order dated 20th of December 22 by annexure 5.
Annexure?
Annexure 5, my lord.
5.
Page 394.
Yes.
Wherein the discharge petition has been rejected. The
Or
allegation.
discharge application. is-
Charge also. Subsequently, charge has been framed.
Framed.
Yes, by annexure 5. That is under challenge, my lord.
Then you file a revision. You file the revision.
Yes, my lord. This is the revision.
This is a revision, huh?
Lordship.
If lordship permits, Lord, may I clarify,
And
Lord?
consulted
They have filed an application on the revision applications filed challenging an order rejecting that discharge application. Subsequently, with the framing of charge, my lord, they come up with an amendment. That application is allowed. You also can see that cost list, my lord, the consulate petition already filed, my lords.
Yes.
So then it needs
For hearing, that's all.
To be
just list after it.
this
Yes.
has to be admitted.
Lordship has admitted my case.
Admitted and
It is admitted issue notice.
my lord, IA is there, my lord.
I also notice on I.
My lord,
You
so
move
far as the-
application. You move
My lord,
application to court.
so far as
Then
the-
council part the petition submits that no the matter is ripe for final hearing. However, due to paucity of time, the same could not be heard. In view thereof, the petitioner seeks liberty to move application before the court below, seeking an adjournment if such application is moved. Same.
Lordship, then fix a date. The reason being, after framing of charge, the trial begins, my lords. All the witness exams will be started, my lords.
Next date of hearing.
So far as the present petitioner is concerned.
For the petition.
Lordship, fix a date.
Date is fixed. Or in all matters.
Obligement.
Yes, next.
140.
Order, what is the vigilance matter, conviction? And pen is there, hearing of it. ଆଉ ଆଜି ତ
ଆଜି କୋଉଠି
ତାକୁ ଛୁଟି ପରେ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ କରିଦେଲେ ଆମେ
ଆପଣ କୁହନ୍ତୁ କେବେ ଡେଟ୍
ଆଜ୍ଞା
ଆପଣ କୁହନ୍ତୁ
ମୁଁ ତ ଅଛି କୁଆଡେ ଯିବାର ନାହିଁ subject to
My lord and brother joins with me in wishing happy and enjoyable vacation.
After vacation ଆସିବ
after vacation
ଦେଖିକି ଡେଟ୍ ଦେଇଦବ ସାର୍ ଡାଇରୀ ଦେଖିଦବ ଦେଖିକି and he will just he will
intimate.
Yes. Thank you.
Well, Royal namaskar.
Sir,